ಎರಡು ಹಿಂಗ್ ಅನ್ಕೋರೆ ಆಪ್ ಡೌನ್ಲೋಡ್ ಮಾಡ್ಬೇಕಲ್ಲ.
Please hand over all post conviction. No, no. Revision is disposed of. Revision is paid. If it's an old matter, I'm sorry. See number? English Mabudi. Very good. Well, thank you for this time list.
Serial number 40.
उसके दाढ़ी सर है ना येल्टे होता है.
Serial number 40 में mainly 2 weeks of foundation.
वही विजय. ये the offense है.
All 47. 427 and why not? 427.
I request to learn for the so one the bit one the you have case file ಮಾಡಿದ್ರೆ ಎಲ್ಲಾದರೂ ರೆಡಿ ಇರಬೇಕು. ಯಾವುದು ರೆಡಿ ಆಗಿದೆ? You are ready in 33. You want adjournment in 33? Yes. Request to learn concept for the petition response form. Yes. Number 57. Hanuman Reddy YS accepts notice for the respondents in 57.1 number. Yaut with discount on date. Just to learn from the learn conflict for the city. Respondent submits. The parties have the response to pay have resolved to amicably settle the dispute. This list on this day after tomorrow. Well, not well. Mr. Mahesh Kumar. What is this? Huh? Number? I thought you were giving something to me. Number 36. For the petition of the respondent. The court, it doesn't look nice. You are a lawyer, you should argue with Karnataka. So number 36 is the request to learn concept for the petition response form. Request to learn concept for the petition response form. Yes, that is. Yes, lawyers.
With my lord's leave. But I'm not keeping well, my lord. Serial number 27, but kindly be adjourned by a week, please, my lord. 27.
Fine.
Well, I'm not keeping well at my appointment at 12 o'clock.
The request to learn counsel for the petition response. Second. Yes, anybody else?
Much obliged.
Correct. Naveen Chandra. For non-submission of appeal memorandum to the council for the petitioner. Pass over. Chandrasekhar HB. Where's the acknowledgement?
Initials collected the paper from the office.
Yes, surviving. Yeah. Surviving, how did you? List after receipt of the report from the police regarding service of notice to the petitioner. Please file it in the register. Time is granted to do the needs. Telling the petition shall stand dismissed. 2 weeks time is granted to do the needs. Office objection at single one. Is office objection? What is it mentioned? Where is the assessment order? What is it mentioned in the assessment order? Produce some material to show that you are the son of Mariappa. Page number? So that I do not want. The Learned Counsel for the petitioner admits that the name of the father of the petitioner is Mariappa, not Chikkanna, but the trial court has mentioned his name as Chikkanna. So he is placed in record the Aadhaar card of the petitioner, which indicates his name as his father's name as Mariappa and not Chikkanna. In view of the above, the office objection at serial number 1 is overruled. What about in the cost title? What have you mentioned? In the cost title of the petition, the office objection is overruled. This is a revision petition for admission. When Krishnamurthy? 1 week. 1 week time is granted to pay the process. Paid the PF. When? Learned Counsel for the petitioner submits the process fee. Other requisites are submitted today. Office is directed to check, verify, and proceed to issue notice. Both court name and case. How this division will be ordered? Yeah, what has happened in revision petition? The revision in right. But if he is discharged with sessions court, how is the revision maintained? Correct. No? Yes, please come to section 370B. 1B.
state government may illegal direct government refers to other than nothing a high court from the original applied order political power
How is the revision maintained? Office objection regarding maintainability is kept open. Issue notice to the respondent. Office objection regarding maintainability. Yes, Amshit Hegde. This revision petition is filed against an interlocutory order passed by the trial court under section 91 of CRPC. Stop. In view of the proviso to section 397. View of in view of 397 subsection 2 of section 397. This revision petition is not maintainable. Hence, office objection regarding maintainability of the revision petition is upheld. The revision petition is dismissed as not maintainable. It is however open for the petitioner to provide such other remedy as is permissible in law.
Petition.
So petition for what?
Petitioner is the husband. He is directed to make a payment of rupees 2,000 per month. Maintenance is his wife. He has raised some payments. He is under the issues. He has one house. But in the meanwhile, execution proceedings, FLW has been issued. And this honorable court on the last date of petition directed the petitioner to submit.
How old is the daughter? How old is the daughter? The final undertaking that you will execute it, to convey it.
Not in a delay referring this petition, 1,040 days.
Oh,
By not delay. But one shot we can close this provided he undertakes.
to serve the notice to the.
But he is not accepted. The council, the direction by the honorable court serves on the council. The council forgot that for the reasons.
Trial court is in Mudgere.
The orange gate, reportedly is, because the title state, and then executive plan
So
also.
what is the property that you have in your name? How small is that?
15 lakhs he says.
This is it a 35 plot.
I would furnish it.
What is the,
One cent, 15 lakhs.
what is the arrears of maintenance?
Others was 3 lakhs 60,000. He says he has already paid. And presently he is,
The Guard Council for the petitioner after obtaining instructions from the petitioner submits that the petitioner is willing to convey a 30-cent plot along with a house situated at Mudgere that stands in the name of the petitioner to the name of the daughter who is in custody of the respondent. Full stop. He submits that the fine levy warrant issued by the trial court may be stayed. He submits that the execution of the fine levy warrant issued by the trial court be stayed in the next date of hearing. View of the aforesaid submission is subject to the petitioner complying with the above. The impugned order. Page. The impugned order dated 26/2/2018, passed by the second additional sessions, impugned order dated 1/4/2017, passed by the Honorable Principal Civil Judge and JMFC Moodgere, Miss 417 of 2013. The state with the next state of freedom. This one is confirmed in appeal, confirmed in criminal appeal so and so by so and so. Full stop. List on 21st February. Well, mail issue notice on IA 1 of 22, as well as on the main division petition. The Bhargavato next is the
Family court alone, advocate is there. Prasanna Kumar, the appointment of the whatever restriction.
family court is in Bangalore. Process irutte kodi. So number 11. Acceptance of notice to auto received by his wife. What is this, Mr. Vinod Prasad? This is only 54 days. Yeah, you should tell your party that 54 days we can't oppose in the court. Right, sir. You should tell your client that you can't oppose a delay of 54 days.
I understand.
Sir, we are not a young lawyer, sir. You're not a young lawyer. You should be.
I was on technically. Give me the police possible and not mistake.
Sir, if a client walks out of your office because she does not listen to what you say. In stature, you are submission Allah. For your stature, it is not a submission that you should be making. So let go of a client if the client is not willing to listen to what you say. Are you at the delay when you are opposite? No, problem is you will be standing on this side someday. Then you will. Kutike illi bartade. Good. Notice issued to respondent number.
He's physically advocated.
The notice issued to the respondent number 2 is served on his wife. Yaar R2 yaar. Who is R2? To accept notice issued to respondent number 2 is served on his wife. Mr. Vinod Prasad, Current Counsel, accepts notice, undertakes to appear for the respondent number 2 also. The office is directed to show his name in the cross statement as the counsel appearing for the respondent number 2. Next, for IA 1 of 22 is filed for condonation of delay of 54 days in filing the application and in filing the revision petition. To stop, it is stated in the affidavit accompanying the application. That due to movement of file from the office of the senior law officer Mysore in Mysore and the Office of the Director of Prosecutions and the Deputy Director of Prosecution and the state government, the revision petition could not be filed in time. This application is seriously opposed by the Joint Council for the respondent number 1 and 2, who contends that the reason assigned for the delay is imaginary and superficial. So next paragraph. Presents a caution for the delay. The reason assigned appears to be reason assigned appears to be acceptable. The reason assigned by the state government in support of its contention that the revision petition could not be filed in time appears probable. Hence, IA 1 of 2022 is allowed and the delay of 54 days in filing the revision petition is condoned. This the revision petition for admission, call for records, and list the revision petition for admission after receipt of records. Suspension, sentence is not suspended. You know what you are trying to convey? 6 weeks time ಬೇಕಾ ಅಂದ್ರೆ ಈ ಆರ್ಡರ್ ಆದ್ಮೇಲೆ ಎಷ್ಟು ಕಟ್ಟಿದ್ರಿ? ಈ ಆರ್ಡರ್ ಆದ್ಮೇಲೆ 50% is how much? 50% ಅಂದ್ರೆ ಎಷ್ಟು?
10
lakhs is the 50%. Check amount history. 10 lakhs. Fine amount history. Fine amount history. $20 lakhs is the fine amount. Out of 20 lakhs, you are required to deposit 50%. 9 lakhs. Process ಯಾಕೆ ಕೊಟ್ಟಿಲ್ಲ ಇನ್ನ ನೀವು? Process ಇವತ್ತು ಕೊಡದೇ ಇದ್ರೆ ಇದು ಎಂಟ್ರಿ ಮಾಡಿದ್ರೆ ವೆಕೆಟ್ ಆಗುತ್ತೆ. ಬರ್ಕೊಳ್ಳಿ. 1 week time is granted to pay the process. Failing which, the order dated 5/1/2023 suspending the order of sentence shall stand cancelled. Process ಕಟ್ಟಿದ್ದೀರಾ? ಕಟ್ಟಿ ಆಯ್ತು ರೀ, ನೀವು 5 ಲಕ್ಷ ಕಟ್ಟಬೇಕಲ್ಲ, ಅಲ್ಲ ಈಗ ಪುಟಪ್ ಮಾಡಿಸಿ, ಪುಟಪ್ ಮಾಡಿಸಿ. Office objections, serial number 5 and 7. Correct provision of law to be mentioned in
Beg to appeal for the petition, my lord. Beg to
Yes.
appeal for the petitioner. And office objection as my colleagues have been complied with. Object to petitioner and complied within a week's time.
1 week time is granted to complete the office objections. Prashant Chandra, 2 weeks time is granted to do the needful. Same order. Same order. Same order. Away ಮಾಡಿ. Not legal. 16 only. Counsel for the petitioner submits to complete office objections during the course of the day. If office objections are complete, list for admission. Mari first. Halima Amin. Office objection regarding maintenance. Appeal is still pending.
The appeal court part.
No, this the judgment was passed from the Supreme Court. The review of the order passed by this also this office objection regarding maintainability of the revision petition is overruled. It's the revision petition for admission. Others, Dangal.
The order dated 27/2/2022 for KAT to dispose of the appeal within 6 months.
When was that order? June 2022.
KAT has returned for extension because candidate one BBMP council has not appeared there.
The letter dated 27/1/2023 addressed by the Karnataka Appellate Tribunal seeking extension of time for disposal of revenue appeal 839, revision appeal 839 of 2011 is produced. The order, this court had passed the order dated, this court had passed an order on 21/6/2022 and had directed the trial court to dispose of the proceedings. They directed the tribunal to dispose of the proceedings within 6 months. Is it 6 months?
Yes, my lord. Yes, my lord.
However, the tribunal has sought for extension of time to dispose of the appeal. In view of the letter referred above, time for extension of disposal of revision appeal 839 of 2011 is extended till June 2023. In the end of June 2023. Samir SN. Yes. Yes, please. Any objection? So idea 1/21 is filed for continuation of delay of 125 days in revision petition. The learned HCGP has no objection for continuation of delay. However, the cause shown for the delay is produced and the same is accepted. Hence, idea 1/2021 is allowed. Idea 125 days in filing the revision petition is condoned. This is the revision petition for admission. Sharbi. Want it to be dismissed as not pressed or what? Conviction set aside, you don't want the conviction to be set aside. But application act counsel for the petitioner is directed to file appropriate application as provided under section 147 of the negotiable instruments. Counsel for the respondent has filed a IA 3 of 2022 for vacating the order. Is it suspension of sentence or stay? Vacating the order of stay. What is the date of the order? order of suspension of sentence. So she contends that though this court had suspended the order of sentence on 25/8/2022 subject to certain conditions, the petitioner had failed to comply with the same, and therefore, the respondent is into difficulty. The petitioner has failed to comply with the conditions as ordered by this court, the respondent is at liberty to execute the order of sentence in accordance in view of the above, in view of the above, IA 3 of 2022 does not survive for consideration. Yes. You please issue, madam. You please enforce the order of sentence. That liberty I have given. See, this order is conditional. If he has not complied with the order, it automatically goes. You need not come and seek for vacating stay. Karnataka, Barodela, without coming to our Monday, I will miss some case. Hello. Case miss agide nodi. Yadon case miss, I think we appointed an amicus curiae in Europe. Hello. I give nodi. We passed more city currently. We called the case 3 times. Nobody appeared. Any objection? But for IA 2 of 22 is filed for conduct of delay for 62 days in filing the the SCG case directed to accept notice for the respondent. Issue notice on IA 2 of 22 as well as on the main division. That has notice over. Huh? The meanwhile, the order of sentence dated so and so, passed by so and so, instance number so and so, is suspended subject to the petitioner depositing 50% of the fine amount, including before the trial court, including the amount already deposited, within a period of 2 weeks, 4 weeks. This term. What is the outline? How much cost you pay? Cost 1,000 rupees per foot. IA 1 of 23 is filed for recalling the order date 4/1/2023. The cost one for recalling the order dated 4/1/2023 is accepted, and the order dated 4/1/2023 is recalled subject to the condition that the petitioner deposits a sum of 1,000 to the High Court registry within a period of 1 week. Settlement markidra. Please don't file a joint memo, madam. Please file an application. What is this 138? 147 nodi. Code 147 code. Please go through section 147. Next, Mr. G. Muralidhar. Password. The Leela the Victory. Password. National part. Password. Password. Shankarappa. Not nice.
Petitioner in demand. Act of justice. The accused number one was working as a manager, top cooperative society, issue of development. During the development time. Accused number two, working as cashier. Accused number three, was working as assistant accountant. The prosecution cases, they were in charge of gas transaction. Accused number three, accused number one, it is a strong woman. And accused number three, it is clear. Cash just. In 70 to 2000. The cash balance was 50,000 and
97,000.
27,022. The next morning, the cash was open. 3 lakhs was missing. So therefore, I say, so that was important to the management. They said on 29, big implementation that they have been trying to pay. They are also that is what that's the letter given by all the. The then after 1.5 years, yeah, 24 when 2001 during the trial before that application was made by Ben. So therefore, we made a permission to PW1 was examined. PW1 was examined. Other witnesses were examined. On the basis of that, the commission made by PW1 as against that, the appeal was passed. The Court of Sessions held that the prior court would not have closed the case. The case was remanded. Accused PW1 had already been examined. Chief examination had been PW was 7 more.
After how many months, after how many years did you pay this 2 lakhs?
So meanwhile, I also had filed petition questioning the action.
But what happened to the internal inquiry conducted? Was any internal inquiry conducted? Was any internal inquiry conducted?
Evidence is always available. 8 witnesses were examined. PW 1 to 6 employees of the bank. PW 1 is the complainant. PW 7 is IO. PW 8 is police. All the witnesses say that we do not know who is responsible for the missing. Who may have committed. It's a case of no evidence.
But only 3 custodians of the currency cash chest. Accused number 1 to 3, they are the joint custodians of the cash chest.
No evidence that bank custodian. So who is responsible? Who operated on the 17th?
Yes.
So who kept the money in the chest? Who out of the money on the next day? All that nominables and all embraces statement. The keys were like these people, therefore they may be responsible. Who is responsible?
Is there anything to show that the last date when the cash was counted, who signed the register?
A1 and A2.
A1 and A2, they are signed. And next day when it was counted, who signed it? Next day count ಮಾಡಿದಾಗ. No. We need to know who was the person responsible. Copy of attendance register, copy of cash summary register, copy of cash summary register. Letter given to the accused person. Key register. Key register ಅಲ್ಲಿ ಯಾರು ತೆಗೆದ್ರು? Evidence for but if the document itself speaks for itself, why should we go to the oral evidence? P10 and P11 and P12 ಅಲ್ಲಿ key register na ಯಾರು ತಕೊಂಡ್ರು ಅವತ್ತು the next day? Yes. ಬ್ಯಾಂಕ್ ಇಂಟ್ರೆಸ್ಟ್ ಎಲ್ಲ ಕಟ್ಟಿದ್ದೀರಾ? 3 lakhs. Please pay the interest as per the banking norms. Pay the interest.
So who is that?
Sir, you owned up your responsibility by paying 3 lakhs.
So because the case was filed against me, we are being made liable.
No, you are.
So therefore, although
You pleaded, sir, virtually you pleaded guilty by paying up the money.
it's not admission of guilt. So that is what the higher court has committed a mistake in saying that you are admitted on guilt. Not admitted on guilt. What they say, they have played with, they say, not in this instance.
Yes, sir. Namantaraj.
I read PW one complaint. The government portion of the other. PW one.
Yes, sir.
And we are not to be made liable with aid of section 34. In order to know section 34, there must be some evidence that jointly. There is no evidence. Year 2001, I was looking at administrative engineering for. William was manager.
Please read the cross-examination portion, that is enough.
It's true that I like this thing. It's true that I do not know. It's true that I cannot tell specifically who supposed to be your mom. It's true that I cannot say that the accused can approve. And therefore, that you know.
Yes, sir.
Although we were not liable to pay any money, we were meant to pay 3 lakhs because an accusation was made against us. So that is the punishment which we did not deserve. Then PW2, another employee, cross-examination. ನಾನು ಚಾಸ ಒಂದರವರೆಗೂ ಹೇಳಿದ ಪ್ರಕಾರ PW1 ಸದರಿ 3 ಲಕ್ಷ ರೂಪಾಯಿಯನ್ನು ಯಾರು ದುರುಪಯೋಗ ನನ್ನ ಸಮಕ್ಷಮ ಯಾವುದೇ ಪಂಚನಾಮೆ ವಿಚಾರಣೆ ಮಾಡಿಲ್ಲ ವಸಂತ್ ಕುಮಾರ್ ಒಂದರವರೆಗೂ ಹೇಳಿದ ಪ್ರಕಾರ ನಾವು ಓದಿರುತ್ತೇವೆ ಸದರಿ 3 ಲಕ್ಷ ರೂಪಾಯಿ ಯಾರು ದುರುಪಯೋಗ ನಿಜ ನಾನು ಚಾಸ ಒಂದರವರೆಗೂ ಹೇಳಿದ ಪ್ರಕಾರ ಸಾಕ್ಷಿ ಸದರಿ 3 ಲಕ್ಷ ರೂಪಾಯಿ ಯಾರು ದುರುಪಯೋಗಪಡಿಸಿಕೊಂಡಿದ್ದಾರೆ
Because on the same day they are cross-examined. So therefore, raise a question. Correct. What is there to show that these people could have won over? Correct. What is there to show that he was won over? He is an employee of the bank. He will be complaining. So why? How could he be won over? And all that he says is, I do not know who has committed the misappropriation.
The document is very clearly. Document is
Both both. Correct. ಈ 3 ಜನದಲ್ಲಿ ದುಡ್ಡು ತೆಗೆದಿರೋದು ಯಾರು? Out of the 3, responsible is different. Who has committed the crime? Who has committed the crime?
Number 1 is the
You could have a very good case on the departmental side. When you are invoking criminal prosecution, you do not point out what is the guilt of each one of them. What is there to show that A1 has committed the theft or A1 has been misappropriated? Exhibit P8 is the cash summary register.
letter given by the accused. Here it is. What document is very clearly said.
Right, who took the keys on the next day?
Manager.
Who was taken it?
No evidence, no evidence.
I the document nodi. Who is accused number one? Accused number one, yaru? What's the name of the accused number one? Tanuja. Chandrasekhar Tanuja. Entrance keys. Strong room keys. What is there to show that any of the accused have taken the keys of the strong room? Right, what is Tanuja yavat tagondidare? 17.5. 17.5 it was 30 lakhs, 97,000. And the exhibit P9 is the next day, 18.5. So is it closing balance or the? Right, closing balance I do. The opening balance I do 27 lakhs. Opening balance is 30 lakhs, 75,648. Please come to this 18.5. Opening balance 30 lakhs, 97,000. Received today 2 lakhs, total 33 lakhs. Paid today 2 lakhs 79. Closing balance 30 lakhs 75,000. 648. Total sum. So actually is 27 lakhs. So closing balance is 27 lakhs on that day. The next day closing balance was 27 lakhs as against 30 lakhs. Correct. So between 17.5 to 18.5, who are the persons who have taken the keys? What? Tanuja manager. Date is 12/4/2000. Who has taken the keys on that particular day? Illide. 12/4/2000 ತಗೊಂಡಿದ್ದಷ್ಟೇ last. 12/4/2000 ಆದ್ಮೇಲೆ there is no entry. Yes, please. ಓಕೆನಾ?
2008.
Yes, it's between 17/5/2000 to 18/5/2000. Who are the persons who operated the cash? Who ಹೇಳ್ತೀರಾ? So there should be something to show that all three of them have gone, taken the 3 lakhs and come out. What is that? Either you should show that all of them have gone inside, taken the 3 lakhs and come out, or one of them has gone inside, taken the 3 lakhs and come out. ಅದಕ್ಕೇನಿದೆ proof? ಬರ್ಕೊಳ್ಳಿ. These revision petitions are filed. These revision petitions are filed by the accused, challenging the judgment of conviction dated so-and-so, passed by so-and-so and CC number so-and-so, convicting them for the offences punishable under section 409, reduced section 34 of IPC, and sentencing them to undergo simple imprisonment for a period of 6 months and to pay a fine of ₹1,000 each. The petitioners have also challenged the judgment passed by the appellate court in criminal appeal 627 of 2012 and 655 of 2012, by which it upheld the judgment of conviction passed by the trial court. Stop. Next paragraph. The case of the prosecution was that the accused number 1 was the manager, while accused number 2 was the cashier and accused number 3 was the assistant accountant at the Sudha Cooperative Bank, Mattikere, Bangalore. Full stop. It was alleged that on 17/5/2000, the closing balance of cash in the currency chest was ₹30,97,022.20. The cash summary register was certified by the accused number 1 and 2. Full stop. Later, on 18/5/2000, the closing balance was found to be rupees 29 lakhs 27,75,648 as against rupees 30,75,648.20. Full stop. It was alleged that there was a shortage of rupees 3 lakhs in the currency chest. Full stop. The accused 1 to 3 were the joint custodian and in possession of the strong rooms, possession of the keys of the strong room and the currency chest. Took up the responsibility to restore the cash. Full stop. However, due to the default of the accused in paying the amount of rupees 3 lakhs, the complaint was lodged on 24/1. 24/1/2001. Stop. The in 2001, the case in crime number so-and-so was registered for the offences punishable under section 409, reduced section 34 IPC. Stop. The investigating officer after recording the statement of the official witnesses and official witnesses were the employees of the bank and the chartered accountant, filed a charge sheet for the said offences. Charge sheet for the offences punishable under section 409, read with section 34, findings. Full stop. The trial court took cognizance of the offence punishable under section 409, read with section 34 IPC. And secured the presence of the accused and released them on bail. Full stop. Copies of the charge sheet was furnished to the accused, and later the accused pleaded not guilty to the charge framed by the trial court under section 409, section 34 IPC. The accused pleaded that they be tried. Consequently, the prosecution examined the complainant as PW1, an assistant manager of the bank as PW2, a senior who was PW3, senior assistant manager as PW3, PW3 is the manager. PW3, the manager of the bank was examined as PW3. An attender was examined as PW4. And an employee of the bank was examined as PW5, who was the witness to the spot master. PW4 and 5 were witnesses to the spot master. And PW6, who is PW6? Who was an office assistant at the bank. And PW8, who was a chartered accountant who certified that there was a shortage of rupees 2 lakhs in the currency chest. And marked exhibits P1 to P15. See P16, of which P7 was the copy of the attendance register of all of the accused. P8 was the cash summary register. P9 was the cash summary register dated 18/5/2000, never 17/5 to cash summary register of 18/5/2000, and a letter submitted by the accused undertaking to replenish a sum of rupees 3 lakhs. P11 and P12 were the key registers of the strong room and the currency chest, while P13 was the complaint lodged by PW1. Full stop. P14 was the spot marker drawn by the investigating officer, and P16A was the audit report of the chartered accountant (PW8). So based on the oral and documentary evidence, the trial court initially held that the statement of the accused was recorded in section 313 of CRPC, who denied the incriminating evidence against them. Full stop. However, they did not lead any evidence in defense. Based on the oral and documentary evidence, the trial court initially acquitted the accused of the offences in terms of its judgment dated 2/7/2008. However, the appellate court in criminal appeal 849 of 2008 reversed the judgment of acquittal and directed the trial court to reconduct a trial and dispose of the case in accordance with the Consequent to the above, the trial court consequent to the above, based on the oral and documentary evidence, the trial court held that the prosecution had proved the guilt of the accused, as they were the persons who were responsible for operating the strong room and the currency chest, and thus convicted them for the said offence and sentenced them to undergo simple imprisonment for a period of 6 months and pay a fine of ₹1,000 each. So being agreed with the said judgment of conviction, the accused filed criminal appeal 627 of 2012 and 655 of 2012. So the appellate court secured the records of the trial court, heard the counsel for the parties, framed points for consideration, and after reappreciating the evidence on record, dismissed the appeal and confirmed the judgment of conviction passed by the trial court. Being agreed by the same, the present revision petitions are filed with the accused number 1, accused number 2 and 3. Stop next for the learned counsel for the petitioner, CH Bhagwan, and learned counsel for accused number 2 and 3, CH Bhagwan, and the learned counsel for the accused number 1, S. Shankarappa, submitted that Hari Shankarappa, SL hoytu submitted alle mail ordi ante alle irbekalla submitted that PW1 was the complainant turned hostile, and he was completely unaware as to who was the person who had misappropriated the sum of ₹3 lakhs. Likewise, PW2 and PW3 turned hostile and claimed that they had adduced evidence based on the instructions given by PW1. PW4 and 5 were the witnesses to the spot murder who also turned hostile. But PW6 was also turned hostile. There was no clear evidence as to the involvement of each of the accused, more particularly the prosecution at present case. More particularly, the prosecution had invoked section 34 of IPC. It was incumbent upon the prosecution to establish the charge against each of the accused, and in the absence of any clear evidence, the trial court as well as the appellate court committed an error in convicting the petitioners, convicting the accused. They also further submitted that the documentary evidence also did not establish the charge against the accused beyond doubt, and therefore, the judgment of conviction passed by the trial court was not justified, and the evidence on record was not sufficient to justify such conviction. The CGP, on the other hand, submitted that exhibit P8 was the summary of the cash register dated 17/5/2000, which showed the closing balance as rupees 30 lakh 70. Closing balance as rupees 30,97,022.20. Full stop. The closing balance on the next day, as per exhibit P9, was rupees 30,75,648.20. However, the actual cash in the currency chest was only a sum of rupees 27,75,648.20. He therefore submitted that there was a shortfall of rupees 3 lakhs in the currency chest. And the accused who are responsible for operating the strong room and the currency chest were responsible for the offense. Full stop. He further submitted that all the accused had submitted a letter as per Exhibit P10 to restore the cash of rupees 3 lakhs. Full stop. We therefore submitted that the accused had tacitly accepted their guilt, and therefore, the trial court and the appellate court were justified in recording a finding of conviction. He also invited the attention of the court to Exhibit P11 and P12, which is the register maintained by the bank, showing the persons who had received the keys of the strong room and the currency chest, and submits that it was only these three people, it was only the accused who are operating the strong room and the currency chest, and therefore they were responsible. Full stop. Next para. I consider the submissions made by the learned counsel for the accused as well as the learned HCG. Full stop. Next. The offence was allegedly detected on 18/5/2000. However, based on the undertaking by the accused, proceedings were not initiated. Criminal proceedings were not initiated against the person responsible till Rawat complaint till 24/12/2001. Full stop. There is no sufficient explanation for the delay in lodging the complaint. Full stop. The claim of the prosecution that the accused had submitted a letter on 29/5/2000 undertaking to restore the cash of rupees 3 lakhs, and that they failed to do so, which resulted in a belated complaint, is wholly unacceptable. Full stop. Be that as it may, none of the prosecution witnesses supported the prosecution, and none of them pointed out the role of each of the accused in the missing currency from the cash chest. Full stop. The accused number 1 was the manager, while accused number 2 and 3 were the cashier and assistant accountant at the bank. And therefore, it was incumbent upon the prosecution to establish the role of each of the accused in the missing cash. Full stop. Except the complaint at Exhibit P1, complaint Exhibit P14, there is no document to establish the guilt of the accused. Even the documentary evidence do not support the prosecution and does not indicate that the accused had does not indicate who amongst the accused had opened the strong room and operated the currency chest on 18/5/2000. Full stop. In that view of the matter, the assumption by the trial court that the accused were guilty of the offences based on the roles and responsibilities of the accused and their job profile, is wholly unjustified. The concept of vicarious liability is wholly unknown to criminal students, and the prosecution was bound to prove the charge against each and every accused by acceptable evidence. In the case on hand, there is no palpable evidence to drive home the guilt of each of the accused, and the trial court as well as the appellate court committed an error in convicting them for the offences punishable in section 409, read with section 34 of IPC. In that view of the matter, this revision petition deserves to be allowed. Consequently, these revision petitions are allowed. The judgment of conviction dated so past case also in CP number so, the consequent order and the consequent sentence are set aside. The accused are acquitted of the said offences and are set free. Stop. Similarly, the judgment of the appellate court in criminal appeal number so is also set aside. Yes. So Raghavendra V. Shankar. What is this?
Education center होता है हमें कार्य में बहुत ऊंचा वाले इंटरेस्ट पर होता है
ಅದೆಲ್ಲ ಆಗಿರೋ ಕೆಲಸ ಸರ್ ಅದೆಲ್ಲ ಇವಾಗ ಇನ್ನೂ ಮದುವೆ ಮಾಡ್ಕೊಂಡಿದ್ದೀರಾ ಎಲ್ಲ ಆಗಿರೋ ಕೆಲಸ ಒಂದು ಕ್ಲೋಸ್ ಮಾಡಿ you pay something and be done with it. So it's a 15-year-old girl child. Can you look after her? Please have some sense before making a submission. 15-year-old girl, can you look after? Son. ಎಲ್ಲಿ ಕೆಲಸ ಮಾಡ್ತೀರಾ? ವ್ಯವಸಾಯ. ಅವನು ತಗೊಂಡು ವ್ಯವಸಾಯಕ್ಕೆ ಹಾಕೋತೀರ. ಏನ್ ಕೊಡ್ತೀರಿ? ಇಲ್ಲ ಕರ್ಕೊಂಡು ಹೋಗಿ ಹೆಂಡ್ತಿನ ಮಗನ್ನ ನಂಬಿಸಿ ಏನೋ ಇದು ಮಾಡಿ ಕರ್ಕೊಂಡು ಹೋಗಿ. ಮುಂದಾಲು ಮದುವೆ ಆಗಿದೆ ಇನ್ನೊಂದು. ಆಯ್ತು, then we'll appoint some, we'll direct the police inspector to come and go and investigate and submit a report whether you are married or not. Thank you. If you're sure about it, then we'll appoint somebody. And really, what will direct the sub-inspector or the police inspector to go verify? ಮಕ್ಕಳು ಯಾರು, ಮಕ್ಕಳು ಏನ್ ಮಾಡ್ತಿದ್ದಾರೆ, ಈಗ ಸ್ಕೂಲಲ್ಲಿ ಓದ್ತಾ ಇದ್ದಾರೆ, ಸ್ಕೂಲ್ ರೆಕಾರ್ಡ್ಸ್ ಎಲ್ಲ ತರಿಸ್ತಾರೆ. You'll get everything. But if you do that, the cost also will increase. Really. 2014, we can't sit on this. Please say something, we'll decide today. No, sorry. Pass over ಮಾಡ್ತೀನಿ, ತಿಳ್ಕೊಂಡು ಹೇಳ್ರಿ. ಎಷ್ಟು ಕೊಡ್ತಾರೆ ಅಂತ ತಿಳ್ಕೊಂಡು ಹೇಳಿ. ಇಲ್ಲಾಂದ್ರೆ I'm going to decide. ಎಷ್ಟು ಕೊಟ್ಟಿದ್ದಾರೆ? How much is paid by ordered by the trial court? What does it? How does it? Why does the trial court reject your claim?
Police statement. Police statement based manage.
What is the reasoning given by the trial court to reject your claim? ಎಲ್ಲಕ್ಕಿಂತ ಮಿಗಿಲಾಗಿ ಎದುರುದಾರ ಪಾಕಿಸ್ತಾನ ಮಾಡಿಕೊಳ್ಳಲು ಈ ನ್ಯಾಯಾಲಯ ಅರ್ಜಿದಾರರಿಗೆ ಸಾಕಷ್ಟು ಅವಕಾಶಗಳನ್ನು ಅರ್ಜಿದಾರರನ್ನು ಮತ್ತು ಆಕೆಯ ಪರ ವಕೀಲರು ಈ ನ್ಯಾಯಾಲಯದ ಮುಂದೆ ಇದುವರೆಗೂ ಸತತವಾಗಿ ಗೈರು ಹಾಜರಾಗಿದೆ. ನೀವು ಅಟೆಂಡ್ ಮಾಡಿಲ್ಲ.
Earlier one criminal case ಆಗಿತ್ತು ಆ ಕೇಸ್ ಅಲ್ಲಿ ಸ್ಟೇಟ್ಮೆಂಟ್ ಕೊಟ್ಟಿದ್ದಾರೆ ಹೋಗುತ್ತೆ
Correct, Mr. How will the judge know what is your case unless you cross-examine him? ನಿಮ್ ತಪ್ಪು ಇಟ್ಕೊಂಡು you have been cross-examined. ನೀವೇನ್ ಕೆಲಸ ಮಾಡ್ತೀರಾ?
ಸೇಲ್ಸ್ ಶಾಪ್ ಅಲ್ಲಿ ಸೇಲ್ಸ್ ಹೋಗ್ತಾರೆ
ಎಷ್ಟು ದುಡಿತೀರಾ ನೀವು? ಕರೆಕ್ಟ್ ಆಗಿ ತಿಳ್ಕೊಂಡು ಹೇಳಿ. ಆಸ್ಕರ್ Korean mall. Yes, Mr. Don't pay any maintenance for her. Pay maintenance for the child. Mr. What will be the education expenses?
60,000 to 75,000.
ಇವತ್ತಿಂದ you only order from today. For the mistake. Proof and ಕೊಟ್ಟಿದ್ದೀರಾ? What is the proof to show that they paid expenses to the child? ಕಾಪಿ ಕೊಟ್ಟಿದ್ದೀರಾ? Where do you stay? ನೀವು ಎಲ್ಲಿರೋದು? ಬಿಡ್ರಿ. ಬಿಡ್ರಿ ಎಷ್ಟು ಜಮೀನ್ ಇದೆ? ಎಷ್ಟಿದೆ ಸರ್ ಜಮೀನು? ಫಸ್ಟ್ ಅಷ್ಟಿದೆ ಕೇಳಿದಕ್ಕೆ ಉತ್ತರ ಕೊಡಿ. ಜಮೀನು ಎಷ್ಟಿದೆ? 4-5 ಎಕರೆ. What is the expense? Monthly expense or yearly expense ಎಷ್ಟು?
Education expenses are 60,000.
Every year 1 lakh. Pay 1 lakh for every year. Huh? Sir, you can't be taking adjournment just like that, sir. Correct. You're taken adjournment on the last day. Only for this purpose. Just tomorrow. ನಾಳೆ ಒಳಗೆ ಹೇಳಿ. Survey number details ತಗೊಂಡು. Get the details of the survey number. Will create a charge over the property. Rahul, right? Yes. Yeah, offense in 324, 326. What is the weapon? Club. What are the injuries? Fracture where? Eighth rib. So is not marked.
Deep examination in Dhaka. We
Correct. Why the X-ray is not marked?
Government is also Interest, then
ಆಯ್ತು 326 ಏನಿದೆ ಸರ್ 326 ಏನಿದೆ or deadly weapon. 326 ಏನಿದೆ ಹೇಳಿ the most it could be treated as a hurt. No. The most it can be 324, not 326. Nature of injury is here. What is the complaint? Please read the complaint. Yes. Hello, Tidra. Where are reading? Oh, read the complaint itself, Mr. ನಾನು ಮೇಲ್ಕಂಡ ವಿಳಾಸದಲ್ಲಿ ಗಿರಾಯಿತ ದಿನಾಂಕ 18/10/2024 ಯಾಕಮ್ಮ ನಾನು ಜೋಳದ ಹೊಲದಲ್ಲಿ ನೀರು ಕಟ್ಟಿದ್ದೇನೆ. ಎಲ್ಲಿಗೆ 226 ಏನಿದೆ ಆಯ್ತು ಓದಿ ಗೂನ್ ಸರ್ಟಿಫಿಕೇಟ್ ಓದಿ. A laceration over the right arm, a contusion over the left side of chest. First, the X-ray chest also shows the 8th rib on the left side. $324 ಅಷ್ಟೇ. ಎಷ್ಟು ಕೊಟ್ಟೆ 324? ಫೈನ್ ಜಾಸ್ತಿ ಮಾಡೋಣ. ಎಷ್ಟು ಫೈನ್ ನೀವೇ ಹೇಳಿ. ರೀಸನಬಲ್ ಎಲ್ಲ ಇಲ್ಲ. ಶುಡ್ ಪೇನ್ ಪಿಂಚ್. ಒಂದು ಮೂಳೆ ಮುರಿದಂಗ ಆಗ್ಬೇಕು ನಿಮ್ಗೆ. There are two accused. Pay 50,000. 50,000 each. 50,000 each. School election season alive. You will get more. Purpose. The petitioners have challenged the first paragraph. Number 2. The case of the prosecution is that on 18/10/2011, the accused assaulted CW1 bracket PW1 with a stick in his right hand and right leg. Down his back and down his back. Causing injuries. Full stop. Case in trial number 212 of 2011 was registered for the offence punishable in section 224. That is section 34 of IPC. Stop. CW1 was examined at General Hospital, Dori Vidnur, where it was found that he had suffered laceration over the right arm, contusion over the left side of the chest. Stop. The X-ray revealed that CW1 had suffered a fracture of the 8th rib. Stop. The investigating officer, after recording the statement of the, after conducting a spot measure and recording the statement of the witnesses and the statement of the medical officer who conducted the, who examined CW1, was submitted a charge sheet for the offences punishable in section 324, 326, that is section 34 of IPC. Full stop. The trial court took cognizance for the said offences and secured the accused and released them on bail. Full stop. The accused pleaded not guilty for the charge under section 324 and 326 of IPC and claimed to be guilty. The prosecution examined PW1 to PW7 and marked exhibit P1 to P5 and the club and the wooden stick used for the alleged offence as MO1 and MO2. Full stop. The statement of the accused under section 313 of CRPC was recorded and they denied the incriminating evidence against them. However, they did not read any evidence in defense. Full stop. Based on oral and documentary evidence, the trial court held that PW6 had proved that the complainant, bracket PW1, had suffered a fracture of the 8th rib. It was caused by the accused by using MO1 and 2. Full stop. It also held that the injury suffered by the PW1 was grievous in nature and PW2 PW2 and held that the injuries were life-threatening and hence, held that the prosecution had proved the guilt of the accused beyond doubt and convicted the accused for the offences punishable under section 324 and 326, section 34 of the PC. Being agreed with the said judgment of conviction, the IPC and sentence them to pay a fine of rupees 3,000 for the offence punishable under section 324, section 34 IPC, and to undergo simple imprisonment for a period of 1 year for the offence punishable, and fine of rupees 5,000 each for the offence punishable under section 326, section 34 of IPC. We will agree by the judgment of conviction, the accused filed criminal appeal number 33 of 2012 and 3 of 2014. To stop, the appellate court secured the records of the trial court for the counsel for the parties. Points for consideration, and after hearing the Honorable counsel for the accused and reappreciating the evidence on record, dismiss the appeal and confirm the judgment of conviction passed to the trial. We review by the same, the present revision petition is filed. Next paragraph. The Honorable counsel for the petitioner submits that the prosecution had not made out, submits that there was no material placed before the trial court to establish the charge under section 326 of IPC. He submitted that there is no proof placed on record to establish that the PW2 had suffered a fracture of the E3. He submits that though PW6 deposed that PW2 had suffered a fracture of the E3, the X-ray was not marked in evidence. He contended that the injuries suffered by the claimant by PW2 was simple in nature, and the object used for the crime was a wooden stick, which was not capable of doing away the life of PW2. He therefore submits that the case under section 324 was made out and not section 326 of IPC. Next, the Honorable counsel for the HCGP on the other hand submitted that PW6 deposed that PW2 had suffered a fracture of the eighth rib, and non-marking of the X-ray was only a mistake on the part of the trial court. He submitted that the X-ray was on record. The trial court ought to have marked the said document. He contended that the weapon used was two sticks. Weapons used were sticks and were capable of doing away the life of PW2, and therefore the trial court and the appellate court were justified in convicting the petitioner accused for the offence punishable under section 326 of IPC. I consider the submission and other responses also. I peruse the records of the trial court as well as the judgment and of the trial court and the appellate court. Next paragraph. The complaint lodged by PW1 discloses that the accused were provoked by PW2 and that they assaulted the PW2 with sticks on his right hand His right leg, right hand on the right leg. Right leg, right hand, sorry. ಜಗಳ ತೆಗೆದು ದೊಣ್ಣೆಯಿಂದ ನನ್ನ ಬಲಕೈ ಹಸ್ತದ on his palm, on his right palm, comma, right leg, right knee, right leg, right knee, comma, on the back, and on the left hand. Full stop. The offenses, the injuries sustained by PW2 were not life-threatening and were not capable of doing away the life of PW2. Full stop. For an offense under section 326 to be attractive, any person should cause grievous hurt with the use of an instrument used for shooting, stabbing, or cutting, or any instrument which is used as a weapon of offense is likely to cause death, or full stop. The injuries suffered by the PW2 as per the deposition, as per the evidence of PW5 was simple in nature, except for the fracture of the 8th rib, which was not life-threatening in any manner. Full stop. There is no evidence to justify the charge under section 326 of IPC, and therefore, the trial court and the appellate court committed an error in convicting the petitioner for the offense punishable in section 326 of IPC. However, the evidence of PW1, PW2, and PW2, PW3, and PW4 supported the case of the prosecution and established the charge under section 324 of IPC. The injuries found on PW2 as deposed by PW6 established that the accused had previously hurt PW2. Full stop. Therefore, the finding of guilt recorded by the trial court and appealed by the appellate court for the offense punishable section 324 IPC is justified and substantiated. That way of the matter, this revision petition is allowed in part. The judgment of conviction dated so and so, passed by so and so, in CC number so and so, for the offense punishable under section 326 of IPC, and the consequent sentence is set aside, and the accused is acquitted of the said offense. Accused are acquitted of the said offense. However, the judgment of conviction convicting the accused for the offense punishable in section 324 of APC is upheld, having regard to the fact that the accused had caused grievous hurt to PW2. They are sentenced to pay fine of rupees 50,000 each, failing which within a period of 4 weeks from today, failing which 2 weeks from today, 2 weeks from today, failing which they shall undergo simple imprisonment for a period of 3 months. 2 weeks, Amadi. You pay it out of your pocket. They say 4 weeks, you should be quiet. We also understand. 2 weeks early. You should learn from your mistakes. All right, keep your apology. Right. This also. Right. 2 weeks. Chokasi Budbek, we also know the realities, difficulties of people. 4 weeks on the quota, we understand. 2 weeks early. No chaukas, no bargaining. 4 weeks anta mari hogu. Don't do this. Next, Kadir. Srinivas CH. He so is permitted to file memo of appeals with a period of 10 days. Mr. Kashyap in night. Then IO has not properly answered you. Yeah, what is the offense? 468, 420 and then DD.
To amendment that was handed over to appeal number 1. I went to the bank to the encashment of the 2 DVs. They said that the second DV, first DV got passed, 80,000. Second DV for 1,50,000, but they said it was fabricated. And I was arrested in the bank. In my defense, I have produced a loan agreement and activity. Shows that I. It's not the beneficiary.
Correct. So this accused number 2 was working in the bank. He has generated a demand draft from her own bank and given it to him. He has encashed it. One DD is encashed. The other DD is yet to be encashed. He goes to the bank, he is caught. Where is the A2 is the only person against whom you can proceed. No, you proceed against A2. A1 ಮೇಲೆ ಏನಿಲ್ಲ. So he says that there is some loan agreement between him and A1. And 34 will not invoke section 34. 34 is not invoked. Then 34 invoke ಆಗಿದೆಯಲ್ರಿ ಆಗಿದೆ.
Intention is clear. Both of the involved. First we will try success, second time.
But no evidence of any of the witnesses will not pertain to fabrication. Handwriting expert was examined. For cross-examination, time was given, but later that witness was not even produced before the court for cross-examination. So in effect, evidence should have been discarded. Evidence is also not discarded. The handwriting expert. And nobody has reposed anything pertaining to A2. Whether she was working in that particular bank, in what capacity.
What are the documents which are cited by the prosecution to establish that this demand draft was actually for 150 rupees? Where are the challans?
But challenge all that they are produced not all for 150,000. They go through the records of the bank. They specify that it was 150. They say that the ED that was given itself was for 80.
Please show the bank challan for getting the demand draft.
Investment challenge.
80 rupees is exhibit P8. And for 150 rupees, it is exhibit P. It's on mark.
you create this one channel, there are two extra sets. This is in.
To find out what has happened to A2. So that is not the, this is not employed in the bank.
After this episode, she was absconded.
Oh.
Because I was the landlord, she was the tenant in my house. She is absconded from the residence at the place. So question in fact has been asked to DW1 as to her whereabouts. She has answered saying that I am not aware. Only if they kindly look at the depositions of all the PWs. None of them have been able to specify regarding the fabrication or as to how A1 is liable. They all assume that A1 has fabricated the document. Even handwriting expert, they say that DD is fabricated pertaining to 1 lakh rupees. The question will not is who fabricated, how it was handed over to me. Question will not was asked on how could you not find out that it was fabricated. In fact, 80,000, even the bank officials have cleared that 80,000 rupees. When the bank officials themselves could not identify, there is no way that A1 could have identified that it is a fabricated document. Only because I was unable to identify the fabricated document, liability cannot come on me. All ingredients will not of 471 will not in my submission is also not met.
Yes, Mr. A2 she was the clearing branch of Zidda. He was in the clearing branch.
She was an attender in JC Road branch of syndicate.
He is an attender.
When issued judgment will not be.
When did you open the bank account? When did you open the bank account?
The deposition of the bank was another aspect you can also see is even when this 80,000 amount was deposited in my bank, I did not withdraw it in one shot.
Doesn't matter, Mr.
And out of 1,50,000 that was deposited, I went only to withdraw 20,000. The intention was not to cheat the bank. They would take the entire amount in one shot.
So when did you open the bank account? Is there any document for that?
Opening of bank account.
The trial court say,
Number one at syndicate bank.
had opened an account in the same branch, Koramangala branch. You guys, from where was this DD generated?
First DD was from AC Road branch. Second DD was given to me from Jalan.
Syndicate.
Syndicate bank, but different branches. DDs have been given by Jalan branch and AC Road branch, not from Koramangala. I had an account here in Koramangala. Koramangala branch. Only written here. We have to see whether the opposite pay order the demand that. And pay order has been not that. The demand has been not. PW1 has before to have done it. He has prepared pay order for 80. Accused number 2 paying 80. In favor of accused number 1, it was identified that it is created. On the other hand, it was created, yes, the accused number 2 had applied for it. Pay order for 80. They are paid rupees 80 and commission. Evidence of PW1 and teller it shows. The pay order was issued for 80 and 1 for 80,000. This implies that the pay order has been obligated to as and the result of the challenge submitted to the DD issued in favor of the it gets clear that the accused number 2 had applied for it. In favor of accused number 1 and paid rupees 150. Evidence of prosecution the demand order was issued for not for.
What is the evidence to show that he has tampered with it? Adikene the evidence. You tamper ಮಾಡೋದಂತ ತೋರಿಸೋದಕ್ಕೆ what is the evidence? Beneficiary is correct, right? Whether he has tampered it or that. Adikene. What is that? What is there to show that he has tampered?
Page 37 of the trial court judgment. First paragraph is not 6 lines from below. Hence, it can very well be presumed that accused number 1 made an wrongful gain by getting the altered amount of 80,000 on the. Then again, at paragraph K in page 39, after discussing on 150. Paragraph A, last 4 lines. When the accused number 1 presented and fabricated within for attachment, without verifying with the branch has to be presumed that accused number 1 had the knowledge of fabrication.
Yes. There is nothing against accused number 1. Therefore, the revision petition is allowed. Including judgment also set aside. Yes. Person L. 290. Who is saying, who is the eyewitness?
It hasn't been to 1 hour.
Who is identified?
Rate of incident. Rate of incident. 31.
51
The investigation officer gave good time. Because if I was I was taking up the car. 23 1 year. 23 1 4 year. He took the car. We came to know that number 1 and 3. The arrested is 9 number 4.
Brother?
A1 and A3 were arrested. Then there is one confession statement.
Confession statement of?
A1 and A3. This is not then thereafter was not 18 to 2012. I know the body worn members they were taken on body worn 18 to 2012. 4 months. Their confession statement and they came to know that after came to know that he had a he was not an exam.
CW9 is examined, CW7.
If you I'm not correct, he has been with them. So they so that was that. Therefore, 19 to 2010, 18 to body warrant, 19 to 2000, very rich day. A1 and A3 together, all of them, they went to the place of CH-20. And they secured the books. Our CH-9 was not at home, therefore, they secured the books of the books and the land house. They don't have to be for large hours. And my lords, in 23 2012, from 19 to 2012, 23 2012, nearly 1 month. This petitioner was
A2.
arrested. Was arrested. Then the 1 second court was even 9 months. There are very much get the court there. ಫಲಿತವನ್ನು ಬರಮಾಡಿ ಮಹತ್ವವನ್ನು ಮಾಡಿ ಸಾಕ್ಷ್ಯವನ್ನು ಎಂದು ಗುರುತಿಸಲಾಗಿದೆ. ಅಲ್ಲಿಂದ ಆರೋಪಿಗಳು ಕೊಟ್ಟ ಪ್ರವೃತ್ತಿ ಹೇಳಿಕೆಗಳಿಗೆ ನಾನು ಮೇರೆಗೆ ಅವರು ಹೊರಗೆ ಮಾರಾಟ ಮಾಡಿದ ಸ್ಥಳವನ್ನು ತೋರಿಸಲು ಮಾಡಿದನು. ಆರೋಪಿಯಿಂದ ಬಂದವರು ಮನೆಯಲ್ಲಿ ಹಾಗೂ ಅಂತ ಇಲ್ಲದೆ ಅಡ್ಡಪಡಿಸಲಿಕ್ಕೆ ನಾನು ಆಧಾರ್ ಕಾರ್ಡ್ಗೆ ಈ ಪ್ರಕರಣದ ಎರಡನೇ ಆರೋಪಿ ಡಾಕ್ಟರ್ ಅನಂತರವರು ಆತ್ಮಹತ್ಯೆ
Let us see the confession statement. Yeah. Exhibit. Exhibit P can, Or 11, 12. So good. We go through this, we'll take it up later. ನೋಡ್ತೀರಾ ಆಮೇಲೆ ಸಮಾನ 2:30.
ನಾನು ಮೇಲ್ಕಂಡ ವಿಳಾಸದಲ್ಲಿ ನನ್ನ ತಾಯಿ ಮತ್ತು ಸಹೋದರನ ವಾಸವಾಗಿದೆ.
ಯಾರ್ದು? Exhibit P10. ಯಾರ್ದು ಅಕ್ಯೂಸ್ ನಂಬರ್? ಅಲ್ಲ, 3 ಜನದ್ದು ಓದಿ. Let us see what they say. Do they say about the ornament which was pledged or the place? ಅದ್ಯಾರ್ದದು? Accused number 1.
ನಾನು ಆಯ್ಕೊಂಡ ವಿಳಾಸ ಬೇಕು ನಮ್ಮ ತಾಯಿ ಮತ್ತು ನಾನು ವರೆಗೂ
He was not there. He was not there when they went to the CW9 was not there at home.
One month. Total collected the very next month.
If you have asked IO, what is the evidence extracted from IO? Why you did not seize it immediately on the 19th? You expect ಮಾಡಿದಿರಾ?
After 4 months, given on the entry for understand, they would have done it on the very same day. Even though it will 9 months, nothing would have stopped.
Right? We do not know whether CW9 was there, was not there.
Investigation is not a daily investigation. You could bring it down from the entire recovery. Till after they waited till record number.
Who was identified MO1? Complaint as identified.
Investigation.
Yeah. You're a habitual offender. Therefore, how can we let you? What about A1 and A3? To serve the sentence. Yes, you are the one who has snatched the chain.
Voluntary statement, not a problem to conclude on a voluntary.
Voluntary statement illa. Voluntary statement leading to recovery of the child.
We don't request, madam. Which-
You cannot, I mean, we don't want these governments to be society. This Girish MP. Huh? Why? It was listed, Mr. a few days back. Huh? Was it listed? Can't keep on listing. Either you argue or we'll close. If you can't argue, we'll look into the file and we'll close it. Yes. Pass over. 2:30. Please argue at 2:30. Not tomorrow, Mr. 2:30, yes. Pass over. Pradeep.
Number 1,
So Naveen Chandra. ಏನು 1:38. Huh? There is no representation for the division petitioner and the respondent. This was finally on date. Patil GS. What are these two revision petitions, madam? The first petition is filed for what? The appellate court enhanced the sentence, enhanced the fine. What about the first petition? To challenge the conviction. Yes, it is. These revision petitions are all of statement of conviction dated 11/10/2017. Sorry. Judgment of conviction and order of sentence dated 25/8/2016. Passed by so and so in CC number 16509 of 2005. And it was confirmed by the appellate court in criminal appeal 1101 of 2016. Criminal revision petition. Criminal revision petition 1162 of 2017 is filed, challenging the judgment. Appellate court reduce the sentence or enhance the sentence? It's filed by the complainant challenging the judgment dated 11/10/2017, passed this also in criminal appeal 1101 of 2016, by which it reduced the sentence of fine. By which it set aside the order passed by the trial court. We should reduce the sentence and reduce the sentence of fine from rupees 34,80,000 to a sum of rupees 17,45,000. Next paragraph. These revision petitions were listed for admission, the parties have filed an application. Section 147 of the negotiable instrument act. I specifically told you to read 147. What did you do? Why you did not read 147? Where have you mentioned? Where have you mentioned, madam? Even after asking you to read, you do this mistake, is it? Madam, have you read 147? Did you read? Yes or no? You read. What did you understand? Please read it again. Please read it, madam, fully. So what you should do? The word used is notwithstanding anything contained in CRPC. Isn't it? So which is a provision that has to be invoked? The file application section 320(4) clause B clause 6 of CRPC, which is treated as an application section 147 of the Negotiable Instruments Act. The parties have settled the dispute, in terms of which the respondent has agreed to receive a sum of rupees 17,45,000. Wait. 17,45,000 towards full and final settlement of the amount payable under the check in question. Stop. It is also stated that a sum of rupees 8,70,000 is already deposited before the trial court, and that the petitioner has today handed over the demand draft for a sum of rupees 5 lakhs. Stop. The petitioner and respondent are present in person, and they acknowledge the terms of settlement. Yes, have you agreed? Yes, terms of settlement in the appeal of the matter, comma. What about graded fine, madam? Graded fine 15%. You have to pay a fine. Judgment. If you withdraw the petition, madam, the judgment of conviction will remain. Please understand. Conviction ಏನಾಗುತ್ತೆ? Set aside agbarwa. Conviction. You don't want the judgment of conviction to be set aside. You are the complainant. Who will pay the, put your accused, complainant. Please read, madam, accused. Please read the judgment. You have to pay a fine of 15% as per the judgment. The reason petition is allowed. The offence committed by the petitioner. The offence committed by the accused. The section 130 of the Negotiable Instruments Act is not founded. Consequently, the judgment of conviction dated so and so, and the order of sentence dated so and so, passed by so and so, is number so and so, is set aside. As a result, the judgment of the appellate court in criminal appeal number so and so is also set aside. Yes. 15% cost, credit cost. Huh? This 1 lakh rupees cost. You will pay in how many days? Who is the accused here? He is the accused. You will have to pay cost. Pardon? You can't pay. If you are able to pay 1745 and you use the process of the court for so long, you have to pay for it. Nothing comes free. You had the option of settling the matter before the trial court itself. You allowed the case to linger on. So therefore, you will have to pay cost, which is 15% of the amount settled as per the judgment of. So whatever, 15% of the amount that is settled. And for whatever money that you have settled, you have agreed to pay 1745 to the complainant. You will have to pay 15% of that 1745. Yes, 15% of that. Total say istic 1370 settle ಆಗಿರೋದು. But why you don't mention, you say 1745? I'm settled in 1370 in fact. Last year, since the accused who is present in person pleads difficulty to pay 15% graded cost as ordered by the apex court in so and so, or this court considers it appropriate to award graded cost of 50,000 rupees payable within period of 2 weeks. Yes. We are reducing it instead of 15%, we are only imposing 50,000. Pay it within 2 weeks. 3 weeks. 3 weeks. On such deposit, the same shall be transferred to the account of the Karnataka State Legal Services Authority. On the deposit of graded cost, the same shall be transferred to the account of form. Yes. Only that. Yes. An offense. 457,380. Check whether this man is alive or not, Kerala state. Huh? There's no representation for the petitioner, though it is called twice in the day. Yeah, anybody willing to? Yes, Subramania. Amicus curiae. Mr. Subramania is requested to assist the court as amicus curiae. The registry is directed to furnish a complete set of the petition papers to be learned amicus curiae. List on and therefore. Is it okay? 22nd February. So HP Leeladhar. Ah. Seven. Huh? Well, only a passing statement made. It's only a passing statement.
No explanation. Only if you are asking. The one of the vehicle has not been examined.
Okay, why is he required?
One of the vehicle has.
Are you not identified? The accused not.
Identification for RCP, according to the person themselves, which is accident to put the under the VM. They were and
Dark color.
not being based on, not recognized. There is the evidence of PW2. You have been informed, the police officer who went to the spot of the and he has made spot marker and others. And he tendered his evidence to us. Also see the evidence of PW 2 and 4.
PW2.
Yes, sir.
And ನೀವೇ ಕರ್ಕೊಂಡು ಹೋಗಿ ಆಸ್ಪತ್ರೆಗೆ ಅಡ್ಮಿಟ್ ಮಾಡ್ತಿರಲ್ಲ.
Yes, now the account says not there. The only thing what I am
So
saying.
your identification.
Identification of the driver is concerned. Driver is concerned. The crucial for the point.
Please read the evidence. Let us. ಕಾರ್ ಚಾಲಕ ರಸ್ತೆ ರಾಕೇಶ್ ಸ್ಥಳದಲ್ಲಿದ್ದರು.
The cross examination of PW1 is CW. She exposed the Apagas correct and motor vehicle number K1. I feel by the
ಏನಾಯ್ತು ದುಡ್ಡಿನ ಬಗ್ಗೆ? ದುಡ್ಡಿನ ಬಗ್ಗೆ ಏನಾಯ್ತು? Compensating the
one guy who has been having the prosecution, he accused in the looking to be first hospital. Thereafter, in all efforts to give him. That aspect has been included in this honorable board meetings.
Yes.
Then, findings of the trial court is your action so far. Another one is totally different. And way, and so you are the match who asked it. But asking the exercise leniently that he is a driver. Then he is capable of 7 years old. 16 years old. 16 years old. But imposition of is lenient.
Yeah, how lenient it should be. What according to it's lenient? What according to
So
you?
far imposition of bail.
Yeah, what according to you is lenient fine?
We usually always now these aspects for us. 10 to 50,000 rupees paid the board has been given. And acquitting as a company. That we have seen now.
Sir. ಒಂದು ಸೈಕಲ್ ಕೊಡಿಸ್ಬಿಡಿ ಸರ್. 15,000 ರೂಪಾಯಿ ಒಂದು ಸೈಕಲ್ ಕೊಡಿಸಿ.
That's what I am submitting for the one.
Be reasonable, that is what I am asking you.
That's what I am submitting.
Compensation should be, it should compensate. It should compensate something.
What I am submitting. So already by the mobile cases. I am not saying that. Second aspect is also a last day. I am not saying that. But you must be clear that as a part of hardship for the previous day expressed. Otherly lenient one. He said that I am not saying it is lenient.
2 lakhs. 2 lakhs is 2 lakhs is the lenient, most lenient view. ನೋಡಿ when you are sentencing a person, it should not be a free bite sentence. Don't worry, sir.
I am not saying, I am not taking about all aspects.
Don't worry.
Only I can feel good.
Don't worry about the concept. The police will get him, they will recover.
I am not saying anything other than that.
You are moving on a state highway.
Second,
You are moving on a state highway. That too in the middle of the forest. Right.
and that road was being under repair. These are the things are there. See, I am not saying that those are aspects you are asking. You have the non-examination, owner of the vehicle. Except this man has.
Correct. The owner of the vehicle has to be examined for what? To identify the accused.
Yes.
Accused is already identified.
Driver and maybe I am not vehicle. Because the second spot for I don't like to hide it matter. Hiding the matter is a very secret. But this circumstance, you know the fact I have to.
ನೀವು ಕಲಿಗೆನೆ ಹೇಳೋದು 3 ಲಕ್ಷ ಬೇಕು ಕೊಟ್ಲೋಣ ಅಂತಂದ್ರೆ ನೋಡಿ.
ಅವನಿಗೂ ಗೊತ್ತಿಲ್ಲ ಅವ್ರ ಸ್ಟೇಟಸ್ ಏನು ಅಲ್ಲ ಬಂದಿದ್ದೀವಿ.
ಏನ್ ಮಾಡ್ತೀವಿ? Yes.
ಅದಕ್ಕೆ ಆಗ ಬಂದಿದ್ದು ವಾಪಸ್ ಬಂದಿದ್ದು. ಅವರಿಗೂ ಸ್ಟೇಟಸ್ ಗೊತ್ತಿಲ್ಲ. ಇಬ್ಬರೇ ಅವರ ಲೆವೆಲ್. ಏನು ಅಂತಂದ್ರೆ ಸ್ವಲ್ಪ ಲೀನಿಯಂಟ್ ಎಕ್ಸ್ಪೆಕ್ಟ್. That's what only.
So you can ask the common pleader. They have been imposing fine of 2 lakh rupees. There in 2023, accident has happened in 2007.
Yes, sir. Notice.
So you have all the time in the world to make money to compensate this man. From 2007 till 2023, 16 ವರ್ಷ
Yes, sir.
60 years ಆಗಿದೆ. So you must have made enough money to pay. ಏನ್ ಮಾಡ್ತೀವಿ ಹೇಳಿ.
So by this concern, I believe I can only feel before the board of the there is factors.
How old was the deceased? PM ನೋಡ್ರಿ. Exhibit T7. Exhibit T7. No. He's 27 years. Years. Yes, Mr. Getty accused them. Accused and the LRs of the deceased. ಯಾವಾಗ ಗುಂಡ್ಲುಪೇಟೆ ಯಾವ್ದು ಆದ್ರೂ you should have got some local surety ಮಾಡಿರ್ತಾರೆ. Both of them. Because attempts made by the counsel for the petitioner to get him. ಯಾವತ್ತು at the request of the learned counsel for at the request of the learned HCGP list on 22nd stop. He is required to secure the legal heirs of the deceased and if possible the petitioner also. In view of the submission by the learned counsel for the petitioner that the petitioner is not responding to the communications. Yes. It's on 22nd. Prakasham Patil. There is no representation for the petitioner, though it is called twice in the day. Anybody, this court deems it appropriate to requisition the services of an amicus curiae. We also pay money, Mr. Somebody should volunteer. Yes, Mr. One of the, you have taken one case, yes, Pancham. Mr. R.D. Pancham is requested to assist the court as an amicus curiae. The registry is directed to furnish a complete set of the petition papers to Mr. R.D. Pancham. List on 23rd February. 304, 304A. Basuraju. We are paying a fee of honorarium of 5,000 rupees. Basuraju, Balu Mahendra. There is no representation for the petitioner, though it is called twice in the day. This court considers it appropriate to seek the assistance of an amicus curiae. Srimati, Madam, Halima Amin is requested to assist the court as an amicus curiae. Registry is directed to furnish a complete, Registry is directed to furnish a complete set of the petition papers to the learned amicus curiae list on 138. Now, HCGP has quoted some judgment of the Supreme Court which says that even we can't dismiss a revision petition due to default. So therefore, this formality, yes. Yes, Prasad. This matter. Explosive act. Violent. Yeah.
Most of the aspect is not done so very. I quote, I have been. only on the basis of charge sheet. There is no evidence at all. Can you see page number 4? Take the page number 4 in the first report order. Bottom is the line. Assistant Conservator of Forest along with the RFO and the veterinary hospital went to this spot and then PM and disposed of the body of the people. And they also conducted Mahajan and assisted. Now, they have lodged a formal complaint with the police and also CPA because the road sector by letters so and so, so and so. Further investigation. They have not taken any action. Further, they summoned assistant executive engineer Viscount, Bhadravati, headquarters, who appeared before him and stated that they have not showed various to illegal access to the current hence he has stopped the security activity. Based on their statement and also statement of the staff and the enquiry report, this it was revealed that Malaysia and others have given the lead very similar to say evidence of only 5 witnesses. They have never said that the Westcom officials is examined. The individual Westcom officials is examined. Then the elected police there are not. They would have examined before the court. And they said that the time of death they are not the most important. Although Kodakova speech to the
Who says that?
PW4. Really, PW1 ಹೇಳ್ತಾನೆ ರಾತ್ರಿ ಎಲ್ಲ ಓಡಾಡ್ತಿದ್ರು.
ಅಲ್ಲ PW4 first you go to PW4.
ಅದಕ್ಕೆ ಡಿಸ್ಕಸ್ ಇದು ಹೇಳ್ಬಿಟ್ಟಿಲ್ಲ. PW1
ಸರ್ ಒಂದೊಂದಾಗಿ ಹೇಳಿ. PW4.
PW4 ಅಲ್ಲಿ 2008 ನಾನು ಸಹಾಯ ಅರಣ್ಯ ಸಮಿತಿ ಅದರಲ್ಲಿ 3 ಕಾಡುಗಳು ಮಲ್ಲೇಶ್ವರ ಜಮೀನಿನಲ್ಲಿ ಹಾಗೂ ಅರಣ್ಯಕ್ಕೆ ನೀಡಿಕೊಳ್ಳುವ ಕನ್ನಡದಲ್ಲಿ ಅಕ್ರಮ ವಿದ್ಯುತ್ ಪರೀಕ್ಷೆ ನಡೆಸಿದ ನಂತರ ಸ್ಥಳದಲ್ಲಿ ಶಿಕ್ಷೆ ಹಾಕಿದೆ. ಹಾಗೂ ರಾಜ್ಯದಲ್ಲಿ ತನಿಖೆ ಮುಂದುವರಿಸಿದೆ. ನಾನು ಸ್ಥಳಕ್ಕೆ ಹೋಗುವ ಮುಂಚೆ ನನ್ನ ಸಿಬ್ಬಂದಿ ನಂತರ ಭದ್ರಾವತಿ ವಲಯ ಕಚೇರಿಗೆ 8 ಗಂಟೆಗೆ ಕರೆದು ವಿಚಾರಣೆ ಮಾಡಿದೆ. ಕಾಡುಕೊಳ್ಳಲು ಸಾವಿಗೆ ನಾನೇ ಕಾರಣ ಎಂದು ಒಪ್ಪಿಕೊಂಡಿದ್ದೆ. ವಿಶ್ವವಿದ್ಯಾಲಯ ಕೋಣೆಗಳ ಮರಣೋತ್ತರ ವರದಿ ತಯಾರಿಸಿ ವಿಚಾರಣೆಗೆ ಸಲ್ಲಿಸಿದ್ದೇನೆ. ವಿಚಾರಣೆ ಸಲ್ಲಿಸಿದ್ದೇನೆ. ದಿನಾಂಕ 21/9/2005 ಸ್ವತಂತ್ರ ಸಾಕ್ಷಿ ಹೇಳಿಕೆಯನ್ನು ಕೂಡ ದಾಖಲಿಸಿದ್ದೇನೆ. ನಾಟ್ ಎಕ್ಸಾಮ್ ಎನಿ ವಿಟ್ನೆಸಸ್.
Who are this ಸ್ವತಂತ್ರ ಸಾಕ್ಷಿಗಳು ಯಾರು?
ಪಬ್ಲಿಕ್ಸ್
ಯಾರು?
ದಾಖಲಿಸಿದ್ದೇನೆ ನಾಟ್ ಎಕ್ಸಾಮ್
ಚಾರ್ಜ್ ಶೀಟ್ ಅಲ್ಲಿ ಇರ್ಬೇಕಲ್ಲ. ಇಲ್ವಾ?
ಮೇಲಧಿಕಾರಿ ಆರೋಪ ಪಟ್ಟಿ ಸಲ್ಲಿಸುವ ಅನುಮತಿ ಕೊಟ್ಟರು ಸಲ್ಲಿಸಿದ್ದಾರೆ. 29/2005 ದಾಖಲೆಯನ್ನು ರೂಪಿಸಿಲ್ಲ. ಕಾಡುಕೋಣ ಉತ್ತರ ಪ್ರದೇಶದಲ್ಲಿ ಜಮೀನಲ್ಲಿ ನೆಲೆಗೊಳಿಸಬೇಕಾಗಿತ್ತು. 1ನೇ ಆರೋಪಿ ಹೇಳಿಕೆಯ ಮೇರೆಗೆ 2ರಿಂದ 4ನೇ ಆರೋಪಿಗಳನ್ನಾಗಿ ಮಾಡಲಾಗಿದೆ. ಮೋಸ್ಟ್ ಇಂಪಾರ್ಟೆಂಟ್ ಒನ್. ಒಂದನೇ ಆರೋಪಿ ನೀಡಿದ ಹೇಳಿಕೆ ಮೇರೆಗೆ 2 ರಿಂದ 4ನೇ ಆರೋಪಿಗಳನ್ನು ಆರೋಪಿಗಳನ್ನಾಗಿ ಮಾಡಲಾಗಿದೆ. Only on the basis. There is no other material. There is no one is eyewitnesses. There is no eyewitness. Only circumstantial evidence. In circumstantial evidence, they have the chain of circumstances that they have to prove. And that is petitioner is concerned. And the chain of circumstances is concerned. They first thing is chain of circumstances. They have to prove that the electrical pole is there or not. First thing. Because at that point of time, electrical, they have to examine the ESCOM machines. There is electrical. Second one is concerned due to electrification, the
Doctor exam ಮಾಡಿದ್ರೇನ್ರಿ?
not examine madam. Right. Even 10 to 2000. This is one of the top. Even the expensive. This is not something. Document. As per the PM report in class. One day more, you get it clearly mentioned.
What was the death due to? Is it due to electric?
It mentioned the PM report. I will come to that as second one is concerned doctor examination doctor. Time of that is not mentioned. Basically, they are not at all to remove the gun control ಆಗಿದ್ದ ಆ ಗೊಂಬೆ ಮೇಲೆ ರಿಕವರ್ ಮಾಡ್ಕೊಂಡಿದ್ದಾರೆ. At least they are not at all photographs also. The 60 recent,
Photographs are marked.
they have taken the
Photographs mark ಆಗಿದೆಯೇನ್ರಿ? ಎಲ್ಲಿದೆ ಫೋಟೋಗ್ರಾಫ್?
ಇಲ್ಲ ಫೋಟೋ ತೆಗೆದಿದ್ವಿ ಅಂತ ಹೇಳ್ತಾರೆ. They are not marked. It's also one of the chain of circumstances. So most important, as I say, petition number 1. It is an allegation as a petition number 1. Who was the owner of the land? Owner of the land is concerned proving that forest official is not a competent authority. Competent authority is considered concerned village accountant.
Yes.
Concerned village accountant has to report before the court saying that he is the owner of the property and the crop is concerned. The crop is concerned. Then it will crop it. There were witnesses in PW2, Joda Bridge. And there is a lot of discrepancies. Recovery is most important aspect is recovery from these accused persons. Only recovery is shown as accused number 1. Accused number 1 is guarding that area. Accused number 1 guarding that area. He voluntarily stated that not is number 2 to 4 assisted. There is no other material. And a sketch, most important thing is the spot sketch is not brought in this case. Everything mark it though. PW 1 heads are there. Where are you? PW 1 mark. Where are you? PW 2 evidence.
What is that?
PW 1 says in the land contract. Even the survey number 29. Three, 4 is also said in the docket. PW3 is PW2.
PW2 says that cod and millet, ragi is grown. Some PW1 says it is groundnut. You can't change overnight.
The debating in that case, because the end of the term is the more important, they are not confident. The land of the first petitioner, the electrical pole and sorry, iron. One single pole in the action the electricity. In the land of petitioner. One land is water, light water, land.
Right, Mr. What about A2 to A4? What is that?
Land one. Yeah, 3 and 4 malad is the end of the.
Okay. What is that to show?
Number 1 and 2. Five.
Three of you? Please come back. Please come back. Somebody should represent your Prakash. Correct, somebody should represent. If somebody doesn't represent, what can be done? Who is appointed? Really, somebody should represent. Nobody was present. No one was present. Please intimate Pancham. When will you argue? Tomorrow. Tomorrow. Pancham ಹೇಳ್ಬೇಕು. 49. Paragraph number 1, paragraph number 2. And the revision petition is listed for admission, the parties have filed an application under section 147 of the negotiable instruments act, wherein they have contended that they settle the dispute at a sum of rupees 12 lakhs. 12 lakhs. 12 lakhs. They still in final settlement of the amount paid under the checking question. Stop. The amount of rupees 6 lakhs which is in deposit before the trial court. The petitioner has no objection for release of the amount of rupees 6 lakhs which is deposit before the trial court to be respondent. This amount of rupees 6 lakhs is out of the sum of rupees 6 lakhs, out of the sum of rupees 6 lakhs, the sum of rupees 2 lakhs is paid by cash to the respondent today. It is acknowledged by the respondent. The remaining sum of rupees 4 lakhs is agreed to be paid within 31/7/2023, for which the respondent has no objection. They also agreed that in the event of the petitioner failing to pay the sum of rupees 4 lakhs by 31/7/2023, the petitioner is liable to, the respondent is entitled to recover the entire amount of rupees 30 lakhs as per the order of the trial court. In view of the application, this revision stop. Third, the counsel for the petitioner as well as the respondent, since the parties have amicably settled the dispute, idea one of so and so is allowed. Consequently, the revision petition is allowed. The offence committed by the petitioner in section 130 of the Negotiable Instrument Act is compounded. As a result, the judgment of conviction dated so and so, and the order of sentence so is set aside. Similarly, the judgment of the appellate court is also set aside. The amount of rupees 6 lakhs deposited by the petitioner before the trial court in order to be released in favor of the respondent. Full stop. The revision petition is subject to this order is subject to compliance of the mutual obligations by the petitioner as mentioned in the application. Cost is for cost. ಏನ್ ಮಾಡೋದು ಜಡ್ಜ್ಮೆಂಟ್ ಇದೆ sentence ಹಾಕೊಂಡು it is clear by the petitioner and the respondent that the petitioner is facing severe financial hardships, but she is not able to pay the graded cost as ordered by the export in so and so, or the same is dispensed. Payment of graded cost is dispensed. Yes. Mr. I think it's supposed to be allowed. Purpose. The petitioners by challenging the judgment dated 25/11/2017 past case also, there is additional civil judge in JNHC, Bhadravati, CC number 2776 of 2011, convicting them for the offences punishable under section 2B of the Wildlife Act, Wildlife Protection Act, 1972. Sentencing them to simple imprisonment for 3 years and fine of rupees 10,000 each. The petitioners are also challenged judgment dated 25/10/2018 passed by the 4th Additional District and Session Judge Moga, sitting at Bhadravati in Criminal Appeal 5037 of 2017, by which it confirmed the judgment of conviction passed by the court. The case of the prosecution was that, of a complaint lodged by CW1. OC number 85 of 2008-2009 was registered on 20th of September 2008. It was alleged in the complaint that when CW1 was that CW1 received confirmed news about hunting of Indian bison, and we reached the spot and inquired with accused number 1. We reached the spot and found that near the land of around the land of accused number 1, a cattle prevention trench was laid by the department, and that 3 male Indian bison were found dead in the trench. Full stop. A1 was found to be guarding the land And when inquired with him, he disclosed that Tammaya A2 na. He disclosed Maleshappa is A2. He disclosed that the accused number 2 was the owner of the land adjacent to the trench, and that he had sowed groundnut in his land, and to protect the crop from being grazed by forest animals, he had drawn electricity from the pole lying nearby. Full stop. He also claimed that 3 wild buffaloes were electrocuted, and that they were disposed of in the cattle trench, in the trench laid by the department. Stop. On further inquiry by CW1, it was noticed that apart from accused number 1, accused number 3 and 4 were also involved in disposing of the carcass of the disposing the carcass. Full stop. The accused number 1 was arrested and the statement was recorded. Full stop. The spot Panchanama was drawn. In the presence of CW2, when the veterinarian was summoned to inspect the dead animals. Stop. Based on the materials collected, the investigating officer, bracket PW5, submitted a charge sheet against the accused for the said offences. Full stop. The trial court took cognizance for the said offences and issued and secured the presence of the accused who were released on bail. Stop. Copies of the charge sheet were produced to them. Full stop. They pleaded not guilty to the charge framed by the trial court and prayed that they be tried. Full stop. The prosecution then examined PW1 to PW5 and marked exhibits P1 to P5 are exhibit P1 to P8. Stop. The statement of the accused was recorded as a the CRPC who denied the evidence used against them. They did not give any evidence in defense. Stop. Based on the order and documentary of Mr. Admele, the prosecution also marked exhibit MO1 and MO2. which were the bamboo poles and GI wire used to electrocute the animals. Statement of accused, huh? No. Based on the original document, the offense, comma, the trial court held that the evidence of PW1, PW3, PW4, and PW5, as well as exhibit P3 to P5, demonstrated beyond doubt the 3 male wild buffaloes were electrocuted in the land belonging to accused number 1. Full stop. It also held that the recovery of MO1 and 2 was proved by PW2, and exhibit P3 and P3 to 5 were the report of the veterinarian who reported that the death was due to electrocution. Full stop. The trial court therefore held that all the accused were involved in the commission of the offense and that the prosecution approved the same beyond any doubt and thus convicted them for the offences punishable under section 1 and sentenced them with for 3 years simple imprisonment and fine of ₹10,000 each. Being agreed by the said judgment of conviction, the accused filed criminal appeal 5037 of 2017. The appellate court held double net comma paragraph number 1011. Stop. The appellate court therefore dismissed the appeal and confirmed the judgment of the conviction passed by the trial court. Being agreed by the above, the revision petition is filed. Next paragraph. The learned counsel for the petitioners accused submitted that inconsistencies galore in the case and there were gaping holes in the case of the prosecution which did not link the accused with the alleged crime. He submitted that PW1 was not an eyewitness. Full stop. He also submitted that when PW1 visited the spot, the carcass of the 3 wild buffaloes was already decaying. Therefore, he contends that without there being any ocular evidence regarding the involvement of the accused in the offense, the entire case was based on circumstantial evidence, namely that accused number 2 was the owner of the land bearing survey number 29. Stop. He contends that there is no document placed on record to establish that accused number 2 was the owner of survey number 29. Contrarily, the accused number 3 and 4 were roped in based on the statement of accused number 1. Therefore, contends that there is no corroborative evidence to establish the statement of accused number 1. And therefore, the trial court as well as the appellate court committed an error in glossing over the inconsistencies in the evidence of the prosecution. Further, he contended that PW1 claimed that accused number 2 had sown groundnut in his land, while PW2 claimed that the accused number 2 had sown millet and jowar in his land. So he also claimed that there was no proof. He claimed that though one of the accused was an electrical engineer, he was given up, and there was no proof that there was a source of electricity lying in the land of the accused number 2 or anywhere near the cattle prevention trench. He therefore submitted that without there being any corroboration and proof of the involvement of the accused in the alleged offence, the trial court as well as the appellate court have assumed the guilt of the accused and have convicted them. Stop. Therefore, praise that the impugned judgment of conviction is set aside. For contrast, the learned HCVP submitted that the death of 3 animals, 3 wild buffaloes due to electrocution is not seriously in dispute. He submitted that there were marks, there were drag marks in the land of the accused number 2, which therefore indicated the complicity of the accused number 2 in the offence. And since he could not have single-handedly disposed of the 3 carcass into the trench, the involvement of accused number 2 and 3, 3 and 4 cannot be ruled out. And this statement of accused number 1 testified the same. Stop. I will rectify the same to stop. He submitted that the learned counsel submitted the petitioner. The learned counsel for the petitioner submitted that the veterinarian was not examined before the court, and the accused did not have an opportunity to confront the evidence of the veterinarian. He submitted that the veterinarian was an expert and his report was admissible in evidence. Stop. He pointed out to exhibit P6, which was the range, which was a sketch of the forest range where the accident, where the incident had occurred. Incident was committed, where the offence was committed. Submitted that accused number 2 being the owner of the land, who was bound to explain as to how and why electricity wires were drawn the electric pole found in the spot mass. That considers submission made by the learned principal accused as well as the learned accused. Next paragraph. The perusal of the judgment of the trial court as well as the judgment of the appellate court indicates that neither of them had applied their mind to the facts, to the evidence on record, but they are proceeding on the presumption that the accused were involved in the offense. Full stop. The trial court and the appellate court have fallen prey to their own prejudices against the accused, rather than determine the case based on the evidence adduced by the prosecution. Stop. Next paragraph. It is seen from the evidence on record that PW1 was not an eyewitness, but when he visited the spot, he found 3 carcasses of 3 male Indian bison, which is a protected animal under the schedule to the Wildlife Protection Act 1972. Full stop. The accused number 1 was a person who was guarding the groundnut crop allegedly in the land belonging to the accused number 2. Full stop. The accused number 1 was confronted by PW1, and accused number 1 is stated to have disclosed that in order to protect the groundnut crop, an electrical line was drawn to prevent wild animals entering the land and ransacking the crop. And the 3 wild buffaloes were electrocuted. It is based upon his statement that accused number 2, 3, and 4 were roped in, and the charge sheet was filed against them. Though there was no evidence linking each one of them to the alleged offense. The prosecution did not even secure documents of land belonging to the accused number 2 to establish that the offense occurred in the land of the accused number 2. Full stop. The prosecution did not even establish the existence of an electric pole or an electric source anywhere near the property of accused number 2. Full stop. The prosecution deliberately gave up the electrical engineer who was arrayed as one of the accused. He could have been cited as a witness to establish the fact that the electrical source was used to draw electricity through an unauthorized line. Full stop. However, the prosecution did nothing in that regard. Full stop. The prosecution had, though, recorded the statement of independent witnesses, it did not examine any of them before the trial court. On the contrary, the witnesses who were examined were only official witnesses belonging to the department. Full stop. The prosecution did not even take care to secure independent witnesses for the purpose of drawing a spot measure, or even at the time of conducting an examination to animals or to dead animals. Full stop. We did not even examine the veterinarian to establish that the death was due to electrocution. Stop. The report of the expert has only a presumptive value, only a probative value, but must be established before the court in accordance with law. And an opportunity should be provided to the accused to demonstrate, to rebut the evidence of such expert. Stop. Therefore, this court is of the opinion that the prosecution did not prove the complicity of the accused in the commission of the said offence, but said offence, and the trial court as well as the appellate court have proceeded to convict the accused based on prejudices and assumptions. To stop in that way of the matter, the in that way of the matter, that way of the matter, without any hesitance, it could be held if the prosecution failed to prove the case against the accused beyond doubt. To stop. Hence, the following order: the revision petition is allowed. The impugned judgment of conviction dated so and so, passed by so and so, and CC number so and so, and the consequent sentence so and so are set aside. Consequently, the judgment of the appellate court in so and so is also set aside. The accused are acquitted of the said offences and are set free. Yes. Yeah. Irrelevant. Yes, I will not say anything on that. Municipal agrees. Yes, Mr. Giri. Right, we'll allow the amount to be released to the respondent. This matter was already heard. Fine hearing act under 2021 matter. The counsel for the petitioner submits that the petitioner is desirous of settling the dispute and that they will work out the same and report to the court as early as possible. This time, on the citizen. Yes. Yes. Wow. The name, do the details. We will not permit you to come to India, madam. Whenever you come to India, you should participate in the proceeding. If you have no objection to come to India, correct, madam? Correct. Why then permanent exemption should be granted to you? So she will not come to India.
She can't come, she can't be.
So it's all right. So far as that accused is concerned, we'll exempt her. What about the other accused?
Husband, he's the only one taking care of her.
So if he comes to India, he has to stay back in India.
He's here.
Conditions for her.
What condition?
Lady is not going to tomorrow is for things.
Like the video conference groups, everything is going. If she can't come, what can you do? If she can't come, what can you do? Video conferencing is it's as good as she's secure. If she appears through video conference, it will have. What's it?
Sorrow report, both of them are Americans. So the husband goes there, wife shall remain it. The wife goes there, husband shall remain it. Notwithstanding that, but the pretty and bottom.
Anyway, the husband says he'll come. The extent of the wife, her. Pardon?
Ultimately, our intention is that let them trial again.
Next one. What about surety? What about surety for your presence? Local surety.
Some cash paper.
Cash deposit, America is reeling under a lot of economic crisis.
Yeah, we will take use of that for next year. It has a deal of it.
What is challenged you? Which accused number 3 and 5 is it? And this lady is accused number 2, 3. So this lady is 3 is the husband. The full. Petitioners have challenged an order dated 7/11/2022 passed by Kerala District Judge Ramnagara, SC number 86 of 2014, by which, an application filed by the petitioners under section 205 of CRPC was dismissed, was rejected. Stop. Let's stop. The petitioners were charge sheeted for the offences punishable under section 376, 377, 420, 114, 201, 417, read with section 415, 506 bracket 1, 120B of IPC. The petitioners were arraigned as accused number 3 and 5. The trial court, after taking cognizance, had registered SC number 86 of 2015 and issued process to the accused. To stop. The accused number, the petitioner number 2 being the accused number 5. The petitioners filed an application under section 205 of the Criminal Procedure Code, pending that they are citizens of America, both of them. They are citizens, they are green card or citizens? Pending that. They are citizens. It is OCA, then it is citizen. Only. Correct, madam. Only if he is a citizen of another country, he will get a OCA. is a citizen of another country, he will be given the OCA status.
Yeah, those can hold it.
So next that.
Population decide.
They are citizens of the United States of America. And that the petitioner number 2 is suffering from, is that
Page number 9.
suffering from erosive lichen planus and neck and spine conditions. Stop. She contends that this is an autoimmune mediated oral and cutaneous inflammatory disease, which results in chronic painful condition affecting all mucosal surfaces of the body. Full stop. She claims that being a rare disorder, there are very few specialized physicians, surgeons who practice in this area. And these conditions have impacted her mobility, balance, and normal physical activities, and therefore she cannot travel to India to attend the proceedings in the case. The petitioner number 1 is the husband of the petitioner number 2, is the only person in the United States, is the only person who is taking care of the petitioner number 2, and therefore, none of them cannot frequently visit India to attend the case, and therefore they filed an application for seeking permanent exemption from appearance before the trial court. Full stop. The trial court rejected this application in the light of the judgment of a coordinate, in the light of the judgment of the apex court in Lily Begum versus Joy Chandra Nagbanshi, 1994, SEC crime 303, contended that and held that exemption under section 205 of CRPC can be granted only in the rarest of the rare cases, and the court should not exercise granting such liberty if the accused are charged with heinous offences such as heinous offences under section 376, 417, 506 IPC. Stop. The trial court therefore rejected the application in terms of the order which is impugned herein. The learned counsel for the petitioner submits that the medical records disclose that yes, ma'am. Disclose that what is this FAAD, madam? What is this MD FAAD? Kathleen Zendeli, MD FAAD. What is that?
Final one is
If she's a gynecologist, how can she comment on this?
Not urinate directly from her own.
How old is she? How old is she? One counsel for the petitioners submit. The petitioner number 2 is 61 years old and is suffering from a rare autoimmune condition, skin condition, which could exacerbate if she undertook frequent travel. Stop. He submits that in view of her condition, she cannot travel to India frequently to attend the case. However, she submits that she would appear through video conference whenever required by the court, and that she would ensure her participation in the trial by furnishing adequate surety to the satisfaction of the trial court. She also submits that the petitioner number 1 would appear before the trial court and this would ward off all apprehension by the prosecution that the petitioners may avoid facing the trial. Stop. She submits that the petitioner number 1 does visit India to supervise the properties belonging to him, held in trust by a family trust, and therefore, family trust will stop. She therefore prays that the application filed by her by the petitioners under section 205 CRPC be considered favorably. Next paragraph, SPP on the other hand submitted that the petitioners are accused of serious offences, serious offences under section 376, 377, 420, 114, 201, 417, Regulation section 415, 5061, 120B LPC. And the subjects that if the petitioners are not brought to trial, the purpose of the prosecution will be lost. Will stop. He further submits that the trial court took cognizance of the offences in the year 2014, and the court has made no headway in the case in view of the incessant challenge to the proceedings by one or the other accused. Stop. He therefore prays that suitable conditions be imposed. He therefore prays that suitable conditions be imposed to ensure the appearance of the petitioners before the trial court. Stop. I consider the submission made by the responsible. Next paragraph. The learned SPP does not dispute the physical condition of the petitioner number 2 and also petition number 2. Stop. He also did not dispute that she is suffering from various ailments which possibly could not permit her to travel to India frequently. Stop. The medical documents placed on record thus indicate that the petitioner number 2 has an increased risk of carcinoma due to lichen planus infection, and therefore the condition needs to be managed carefully on a long-term basis. Stop. It is also very likely that her travel to India, her frequent travel to India, can worsen the condition. Stop. If the petitioner number 2 is under constant medical treatment by a team of doctors in the United States of America, it is not prudent to expect the petitioner number 2 to visit, to attend the court hearings on a day-to-day basis. However, she shall participate in the trial through video conference as per the rules which provides, as per the video conferencing rules prescribed by the state or what? By the High Court or by this one? Video conference rules, by this court. It can also provide adequate surety to the satisfaction of the trial court to ensure that she participates in the proceedings before the trial court. Full stop. Since the Legal Counsel for the petitioners has submitted that the petitioner number 1 would attend the hearings of the court, this court does not consider it necessary to dispense his personal presence before the trial court. He has to come. Then you have to come when your presence is required. Only when the presence is required. Oh, yeah, I think. Never necessary. Never necessary. It's a following order. If the revision petition is allowed in part, the personal presence of the petitioner number 2 is dispensed permanently, subject to the following condition. Number 1, she shall undertake to appear on all hearing dates through video conference as per the rules prescribed by this court. She shall furnish 2 local sureties to ensure her presence on all hearing dates before the trial court. Number 3, she shall not seek any adjournment of the proceedings when it is slated for recording the evidence of the prosecution witnesses, and also at the time of pronouncing judgment. Number 4, the petitioner number 1 shall remain present whenever he is absolutely required by the trial court. In the event of the petitioner number 1 failing to appear before the trial court on such dates, the trial court is directed to issue appropriate communication to the immigration authorities to ensure that the petitioner number 1 shall not be allowed to return will not be allowed to leave India in case he enters India until disposal, enters India till the disposal of the trial before the trial. Yes. Whenever required. The estate is how much? 5 lakhs. 5 lakhs.
How much your lordship should not
No, surety, madam, surety. Surety for some of it is 25 lakhs.
your lordship. No, your lordship.
55 lakhs here. 55 lakhs here. 25 lakhs. Madam, it's only surety, you are not depositing, you are not furnishing cash surety.
No.
Not always. Yes.
That one observation maybe.
Not always, ma'am. That is why I said, whenever you are required, for example, if it is listed for examination of the witnesses, you can't say that, okay, I'll seek for exemption. No, you can't say that.
The lordship, with respect to that particular, I have judgment to lordship, that even examination of witnesses are not needed. I have judgment on that. To submit them to the-
Correct, madam. Please see section 273. All evidence have to be recorded in his presence. Everything can be dispensed. We can even permit you to appear through VC, no dispute. Whenever it is required, for example, judgment has to be pronounced, your presence has to be secure. Therefore, whenever absolutely required. Yes.
There is this one particular paragraph there,
Please read.
taking into consideration the entire facts and circumstances of the ground, taking the gap. Can we see advertisement that? There was sufficient, we have to use the sufficient number made of granting done. The evidence is correct. Managed to commit error not advancing without exception and damage. Management and the section for right affecting that and I thought in order observe that there is another. That it is not necessary about even in the first.
No, please, you said you.
Please find me a-
Yes, madam, there are certain stages in a criminal case where you have to be personally present. On that, you can't seek for dispense or exemption. There are certain stages in a criminal case.
There is this one observation. The principle of grant of exemption.
There's a video conference room to be in. You have a copy of the video conference. What does it permit, what it does not permit? That's it.
The principles before the, by which the interest of reference can be protected and grant of exemption not happen. Nothing is on record at any point of time, any immediately or completely. So maybe some time. I think not come. But in case of the other two.
Is that a fact? Is that a fact? That they have come to appear before the court from 2014.
Even recently, one was had visited India in October 2023.
Yes, madam, whenever you come, if you can come to India, you can also attend the case. In America, people are always alone. You only find husband and wife, nobody else. That is how life goes on in America. You have 9/11, you have that, you have this. America is not India, madam. Streaming of charge ಆಗಿದೆಯಾ? Charge ಆಗಿದೆಯಾ? ಇನ್ನಾಗಿಲ್ಲ.
We are acting completely against. One. Thank you.
Are you optimistic of getting him? Please go through the video conference rules. What is permitted in the rules is all provided. In case the person to be examined is an accused, prosecution will confirm the location of the accused at the remote point. The various requirements, you have to pay the cost. So many requirements. Routines. So according to the video conference rules prescribed by the court. Yes, madam, you are also permitted to appear. Only when it is absolutely necessary. Yes, why not? Even in cases where accused are on bail. So don't expect a person in USA to come and attend a case for mere adjournment. Because I mold it, madam, accordingly based on the video conference rules. ಎಲ್ಲಿ? The trial court is directed to expedite the case as early as possible, as against the petitioner's hearing, by splitting up the case. And the same shall not exceed 2 years. 2 years from now. Yes.
Okay.
Yes. Vijay Kumar. Anand. Any offense?
Loan amount is 70 lakhs.
What was the transaction?
The hand loan transaction.
And loan.
Hand loan. Interest component was 16 lakhs. Together it is 96 lakhs.
Interest component is 68 lakhs.
16 lakhs.
16.
Once.
Ah.
So total check amount was 96 lakhs.
What was the agreement?
But couple of cases that for some VDA work in respect of lands in Arkavati layout, I had borrowed 80 lakhs. And I issued 10 checks of 8 lakhs each. Thereafter, 2 checks on the interest form.
Exhibit P1 and
Exhibit P1, Lord, the agreement of sale I have executed in respect of 3 acres of my land in Ramnagara Taluk. That is as a guarantee for the repayment of loan.
is there any mention of this check?
No mention of checks there.
40 lakhs. Exhibit P2 is admitted.
Exhibit P2 is like this is the letter of confirmation.
Okay, what remains?
Brief background to what actually happened.
What actually happened, I'm not interested.
No,
Whether you are so-
On the record, but not off the record. The complaints case itself. In April of 2014, I approached him for a loan of 80 lakhs. And he says 20 lakhs he gave me by 2 checks, by way of 2 checks, 10 lakhs each. The remaining 60 lakhs he gave me in cash. And on the same day of the transaction, 25th of April 2014, I executed exhibit P1. But my defense was, I never, and he said, the purpose of this 80 lakhs was for some VDA work in respect of lands in Arkavati. That is Achit. My defense was only 20 lakhs I borrowed. The remaining 20 lakhs was the interest. So for 40 lakhs as a guarantee, I have executed this agreement of sale at exhibit P1, which shows a consideration of 42 lakhs and that I have received already 40. That was the guarantee for the repayment. And towards another 40 lakhs, 20 lakhs, I had issued 2 checks, 2020. That is dated in February of 2015. But in February of 2015, when I failed to make payment, this person came and coerced me into issuing remaining 8 checks for 10 lakhs each. And these earlier checks which I issued misappropriated interest. But my only submission is, courts below have failed to appreciate the inherent improbabilities of the complaints. Not very well aware. We can raise a probable defense that creates a
But
doubt.
that is right. If you don't dispute exhibit P2, what remains?
But exhibit P2 also, I said, February 2015, he took this document from me under coercion, along with the each. But if the entirety of the complainant's case is taken, but complainant claims that the purpose of this loan was to get some.
But here no evidence of Madilla.
It's clear, your question is aware that Applies my defense.
Not probably, if you admit exhibit P2 and you say that yes, 80 lakhs I borrowed. What problem?
When the complainant in the cross-examination says 40 lakhs was towards purchase of my land and for 40 lakhs, remaining 40 lakhs was loan, thereby reneging on his own case. But his case was 80 lakhs for some PDA work in certain lands. He admits that lands have been long since acquired by BDA in the year 2004. And in 2014, he says, I took 80 lakhs. Thereafter, he says 40 lakhs was for purchase of your land and 40 lakhs was for loan.
I have handled the account cases, I know how to.
Those matters. But the way the complainant contradicts himself, he departs from his own case. He says 40 lakhs was for the purchase of my land as per the exhibit P1 agreement. Then the remaining 40 lakhs was for my loan. If it was a clear case of where I borrowed 80 lakhs, why should this confusion occur at all? Contradiction occur at all? And he says now he also.
What do you want to do? What do you want to do?
Even if going by his case, 80 lakhs, exhibit P2 which I have admitted, 80 lakhs is the check amount, sorry, the loan amount. The 16 lakhs is more shaded in grey. That's interest amount. So, you get some relief in so far I can do the loan amount of 80 lakhs. That's some compensation of 3 to 5 lakhs.
Oh, but when was this transaction? 2014.
2014.
We are in 2022.
Yes. 8
long years have gone by. 80 lakhs would have become 8 crores. Well, again, Malaka, you have agreed to it with eyes wide open. You agreed to it.
Even in the fine amount to that, that's all I press because there is nothing more.
I have understood that. Is there a possibility of a settlement is what I am asking you.
This note was paid way back in 2000.
That also I have understood. I told it. Is there a possibility of a settlement? No settlement. Yeah.
All I'm saying is 80 lakhs is the loan amount. 5 lakhs of, because the lot importantly, but if really 16 lakhs was the interest component, when exhibit P2 I admit 80 lakhs, I would definitely have mentioned that 16 lakhs is another checks I am giving for. Surprisingly, that is missing in exhibit P. That shows that checks have been misused.
What is there to show? What is there to show that this amount was carried interest?
Income produced and store the property.
So what is there to show that this amount carried interest? The agreement, did it provide for any grant of interest, payment of interest? Let us see exhibit P2. What does he say in it?
Exhibit P2 the lender, but loan was taken 80 lakhs. This amount has been shown in the income tax.
Not on that. Is there anything between the petitioner and the respondent for payment of interest?
That's what is exhibit P2. Tax is the government used
I agree, 80 lakhs ಬರ್ತದೆ ನಿಮಗೆ ಇಂಟ್ರೆಸ್ಟ್ 16 ಲಕ್ಷ justify ಮಾಡಿ ಎಲ್ಲಿದೆ what is there to show that
exhibit P2 ನಲ್ಲಿಲ್ಲ
ಎಲ್ಲಿದೆ ಆಯ್ತು exhibit P2 ಎಲ್ಲಿದೆ
exhibit P2 ನಲ್ಲಿಲ್ಲ in our complaint we have barely stated.
Yes. That can't be a debt, mister. Interest cannot be a debt unless you agree.
Yes, and yes, he has given checks of 16 lakhs and interest.
Only the 16 lakhs check. Where is the check?
ಒಂದು 10 ವರ್ಷ ಒಂದು 6 ಲಕ್ಷ
The sum of all these checks is 96 lakhs, is it?
Right.
The total value of all these checks.
80 lakhs is the no more. 80 lakhs.
Correct, you check 96 lakhs ಕೊಟ್ಟಿದ್ಯಾ?
Not in one stretch.
10 lakhs, it is 29
4-9 is for 6 lakhs.
29.
ಎಷ್ಟು ಎಷ್ಟು ಚೆಕ್ಸ್ ಕೊಟ್ಟಿದ್ರೆ ಇನ್ನೇನ್ ಮಾಡಿ 16 ಲಕ್ಷಕ್ಕೂ ಚೆಕ್ ಕೊಟ್ಟಿದ್ರಲ್ಲ.
This is the more, not.
No, you drawn a check. You drawn a check.
Lordship says that his own complainant's case, he says, these checks were issued for September, when I agreed to pay the principal amount in April itself. It's highly improbable when I was
Sorry.
agreed to pay the principal amount on 15th of April.
The complaint discloses, sorry, the records of the transport disclose that the complainant had agreed to advance a loan of rupees 80 lakhs to the accused. Stop. As the first installment, the complainant paid the sum of rupees 40 lakhs. And the accused secured it by executing a sale agreement in respect of 3.03 acres situated at Dotta Mannu Gudde village, Kasba Hubli, Ramnagara Taluk. Stop. In respect to the remaining 40 lakhs, which was paid by cash, the accused, in respect of the remaining 40 lakhs, the sum of this 20 lakhs was paid by a check, and the balance 20 lakhs was paid by cash. And towards repayment of the said amount of rupees 40 lakhs, the accused issued 2 post-dated checks for a sum of rupees 20 lakhs each. Stop. It was agreed. The complaint claimed that it was agreed between him and the accused. But after the entire amount of rupees 80 lakhs was repaid with interest of rupees 16 lakhs, the sale agreement dated 25/4/2014 would be cancelled. Stop. The complainant alleged that when he approached the accused during February 2015, he requested for more time for repayment of the entire loan amount with interest. Stop. The accused is stated to have collected back the 2 checks for rupees 20 lakhs each and replaced the same with 8 checks for rupees 10 lakhs each. 10 lakhs each. Stop. He also issued 2 post-dated checks for rupees 10 lakhs and rupees 6 lakhs towards the interest. Stop. These checks were dishonored when presented for encashment due to insufficient funds, which prompted the complainant to initiate prosecution of the accused for the offences punishable under section 138 of the Negotiable Instruments Act. Stop. The notice issued by the complainant was served,
Yes,
was served on the accused, who neither replied nor
I have replied.
who replied untenably and refused to pay the amount covered payable under the check. Question. Full stop. The complainant therefore launched prosecution of the accused for the offence punishable under section 120 of the Negotiable Instruments Act. Full stop. The trial court recorded the sworn statement of the recorded the pre-summons evidence of the complainant and registered CC number so and so and issued process to the accused. Full stop. The accused appeared and was released on bail. Full stop. He pleaded not guilty and claimed to be tried. Full stop. The complainant was examined as PW1 and he marked exhibits P12, P33. The statement of the accused was recorded in section 313, who denied the evidence against him, appearing against him, but did not lead any evidence in defense. Based on the oral and documentary evidence, the trial court held that the accused admitted exhibit P2, which was a letter of commitment executed by him in favor of the complainant, wherein he had categorically admitted about the loan of rupees 80 lakhs raised from the complainant. Full stop. It also held that the payment of rupees 80 lakhs was reflected in the income tax returns of the complainant, and the passbook of the complainant established the payments made to him, payments made to the accused. Full stop. It also produced exhibit P1, which was the sale agreement executed by the accused in favor of the complainant, and held that the checks in question were drawn by the accused towards repayment of the debt, and therefore repayment of the debt. Full stop. The trial court drew the presumption under section 118 and 113 of the Negotiable Instruments Act and held that the accused did not rebut the presumption by a plausible defense, and therefore, convicted him for the offence punishable in section 138 of the Negotiable Instruments Act and sentenced him to pay a fine of rupees 97 lakhs. Full stop. An appeal preferred by the accused before the appellate court was dismissed. Being agreed by the judgment of the trial court and the appellate court, the present revision petition is filed. The learned counsel for the accused submitted that the sum of rupees 80 lakhs was paid by the complainant for the purpose of using it for deletion of the land belonging to the complainant, bearing survey number 101/1 and 82/4, situated Kanisandra and Rachinalli villages, which were acquired by the state government for the purpose of formation of Artavati layout. Full stop. We submitted that the accused had used up these funds on the instructions of the complainant, and therefore, there was no corresponding liability to return the money to the complainant. Full stop. Further, he submitted that there is no agreement to pay interest, and the complainant clearly mentioned in his complaint that the sum of rupees 16 lakhs claimed by the complainant was towards interest. Full stop. So we contended that having regard to the transaction between the parties, comma, it is a reply layer telegram. Whatever mentioned in the reply.
Exhibit 27.
Yes. Whatever mentioned.
My submission, exhibit 27A.
20 lakhs was taken as a loan. The remaining 20 lakhs was towards interest. That is all. And 2 checks were given by me. Other 4 checks was given by me.
They submitted that that the notice under section 130 was replied, which sets the stage, which set out the defense of the accused. So we submitted that the amount of rupees 80 lakhs was not the principal amount, but a large part of it was towards interest. Stop. Interest, and therefore, comma, the checks cannot be construed as drawn towards payment of a lawful debt. Stop. For contrast, Legal Counsel for the complaint submitted that the accused had admitted his liability to an extent of 80 lakhs in terms of Exhibit P2. They had also passed on 2 checks for sum of rupees 16 lakhs, being the amount payable towards interest. Stop. He submitted that the signatures of the accused on the checks in question was not disputed, and also that the checks were drawn from his account was also not disputed, and therefore, comma, the trial court as well as the appellate court were justified in drawing the presumption under section 118 and 113 of the Negotiable Instruments Act. We contended that the bank passbooks clearly indicated the amounts paid to the accused, which clearly probabilized the fact that the complainant had paid some of rupees 80 lakhs as hand loan to the accused, and that the accused towards repayment of the said amount along with interest had drawn the checks in question. So I consider the submission made by the Legal Counsel for the accused as well as the Legal Counsel for the complainant. I have also produced the records of the trial court, its judgment as well as the judgment of the appellate court. Next paragraph. The Exhibit P2, next paragraph. The fact that the accused had executed an agreement of sale in favor of the complainant as per Exhibit P1 is not seriously contested. So the complainant claimed that this agreement was executed as security for a sum of rupees 40 lakhs that was initially paid by him to the accused. Full stop. Subsequent to the agreement at Exhibit P1, various other payments are made by the complainant to the accused, which is evident from Exhibit P. Exhibit P33. Full stop. The income tax returns filed by the complainant as per Exhibit P28 to 30 also indicate that the complainant had disclosed these amounts as payable or as receivable from the accused. Full stop. The letter of commitment issued by the accused as per Exhibit P2 sealed his fate, as he categorically admitted that he had raised a loan of rupees 80 lakhs and was liable to repay the same. Full stop. In that way of the matter, since the trial court was expected to summarily consider the case, summarily try the case, and in view of the colossal material placed on record by the complainant, indicating the transaction as well as the liability of the accused, the judgment of the trial court does not warrant interference. Similarly, the judgment of the appellate court also does not warrant interference. This is revision petition lacks any amount in deposit, it shall be released in favor of the respondent. You are not filed any. ನೀವು ಹಾಕ್ಬೇಕಲ್ರಿ ಅದೇನೋ ರಾಗೇಗೂಡಲ್ಲಿ ಹೋಗಿ ಏನೋ ಮೊಟ್ಟೆ ಇರ್ತಂತಲ್ಲ ಹಂಗಾಯ್ತು ಅಂತಂದ್ರೆ ಅವ್ರ ಕೇಸಲ್ಲಿ ಅವಕ್ಕೆ ನಿವಾಸ ಇಟ್ಸ್ ನಾಟ್ MVC ಕೇಸ್ ಮಿಸ್ಟರ್ ದ ಪಾಂಡುರಂಗ್ ನಾಯ್ಕ್ PN ಹರೀಶ್ ಏನಕ್ಕೆ ಸೆಟಲ್ಮೆಂಟ್ ಮಾಡಿಸ್ತೀರಾ ಸೆಟಲ್ಮೆಂಟ್ ಮಾಡಿಸಿದ್ರೆ ಮಾತ್ರ ಟೈಮ್ ಸೆಟಲ್ಮೆಂಟ್ ಮಾಡಿಸಂಗಿದ್ರೆ ಟೈಮ್ counsel for the petitioner submits that the parties are trying to that the petitioner is desirous of settling the dispute and that the same would be reported to the court at the earliest. Yavat beku date heli sir 2 weeks 2 weeks 2 weeks. Yes, Mr. Sharad Gowda.
Respondent present, my lord. Respondent present.
What is this?
Concurrent proceeding. Concurrent order of condition. Point was on the complainant goes his statement, but the evidence is available by a CPA holder. He is having no personal knowledge. One of the evidence required that he was not having personal knowledge about this matter.
When will admit it? Yes, Mr.
Suresh, my lord, Suresh.
ನಿಮಗೆ ಗೊತ್ತಿದೆ ಈ ಕೇಸ್ ಬಗ್ಗೆ
Case ಬಗ್ಗೆ ಗೊತ್ತಿದೆ, but I was not present in as a witness. But I have given the GPA, taken the GPA from the respondent and appeared in the cross-examination each and every stage of the trial court as well as this one, session court, my lord.
Who are you related?
Is she known to me?
Are you related to her?
No, sir. She is my community lady.
She belongs to your community.
Yes, my lord.
Did you see the transaction happen between the complainant and the accused?
They are admitted in the cases.
Alre, ನಿಮ್ಮ ಮುಂದೆ ಆಯ್ತೇನ್ರಿ?
ಇಲ್ಲ ಸರ್, ನಮ್ಮ ಮುಂದಾಗಿದೆ.
ನಿಮ್ಮ ಮುಂದೆ ಆಗಿಲ್ಲ. Then how can you become a GPA holder?
No, she was unable to come to the court, Your Honor. That's why I taken the GPA and
The court would have come to her house.
Sorry.
Court can come to her house.
Her mother was
evidence ಹೇಳ್ತೀರಾ?
Her mother was ailing. That's why she is taking care of her mother.
Mr. Suresh DK.
Yes, Your Honor. Yes, my lord.
ಕಣ್ಣಾರೆ ಕಾಣದಿರೋದನ್ನ ಬಾಯಾರೆ ಹೆಂಗ್ ಹೇಳ್ತೀರಾ?
No, sir, check was bounced. They are not paid any stop payment to the bank for the stopping of
Not
the
on
payment.
that. What was the transaction?
Transaction. They are 3 persons are students of this PV Lakshmi, Your Honor, my lord. She was working as a tutor in some government institution. They were known to them and they were having a transactions.
But ಹೆಂಗೆ ನೀವು GPA holder ಹೆಂಗ್ ಆಗ್ತೀರಾ?
And I admit this cross-examination that he is getting evidence on what is told to him by the complainant. Para 30 crore, page 11 of the trial court judgment.
ಏನ್ ಸೆಟಲ್ಮೆಂಟ್ ಮಾಡ್ಕೊಳ್ಳಿ.
ಇನ್ನೊಂದು ಕನೆಕ್ಟೆಡ್ ಕೇಸ್ ಬಂದವ್ರಿ, ಅಡ್ಮಿಟ್ ಆದ
ಅಡ್ಮಿಟ್ ಮಾಡಿ ಆಗೋದೇ ಇಲ್ಲ. ಅಡ್ಮಿಟ್ ಆದ್ರೆ ದಿಸ್ ಲೇಡಿ
ಕನೆಕ್ಟೆಡ್ ಕೇಸ್ ಐ ಡೋಂಟ್ ಹ್ಯಾವ್ ದಿಸ್.
ಏನೋ ಎಷ್ಟಿದೆ? ವಾಟ್ ಇಸ್ ಚೆಕ್ ಅಮೌಂಟ್?
Check amount is 50,000, my lord.
50,000
The statement is for 70,000 and 60,000 to the complainant and 10,000 to the government exchequer.
ಫೈಟ್ ಮಾಡೋದಕ್ಕೆ ಆಗಲ್ಲ ಮೇಡಮ್. I won't have this.
ಮತ್ತೆ ಏನ್ 50,000 ರೂಪಾಯಿ ಕೊಟ್ಟು ಕ್ಲೋಸ್ ಮಾಡಿ 60,000 70,000 ಹೇಳಿದ್ದಾರೆ. Yes.
This case, my lords,
ಆಯ್ತು ಸೆಟಲ್ಮೆಂಟ್ ಮಾಡ್ಕೊಂಡು ಯು ನೋ ದ ಟ್ರಾನ್ಸಾಕ್ಷನ್ ಕೊಟ್ಟಿರೋದು ತಗೊಂಡ್ರೋದು ಅವ್ರಿಗೆ ಗೊತ್ತಿರುತ್ತೆ. ಏನ್ ಮಾಡ್ತೀರಿ ಹೇಳಿ?
legally important.
ಎಸ್ ಎಸ್ ಮಿಸ್ಟರ್ ಪಾಂಡುರಂಗ, ಸಾರಿ ಸುರೇಶ್.
Yes, sir, they are ready to pay the money. We are ready, sir. We are accepting the judgment of the trial court as well as.
4 ಲಕ್ಷದೇನೋ ಇದೆಯಂತಲ್ಲ ಬೇರೆ ಕೇಸು.
ಬೇಕಾದಷ್ಟು ಸರ್ 5-6 ಕೇಸ್ ಪ್ರೀವಿಯಸ್ ಕೌನ್ಸಿಲ್ ಅಡ್ವೊಕೇಟ್ 5-6 ಕೇಸ್ ಹಾಕಿದ್ದಾರೆ ಈ ತರ.
ತಾವು ಬರೀ ಒನ್ ವೇ ನಲ್ಲೇ ಹೋಗೋದು ನೀವು?
ಇಲ್ಲ ಸರ್, ಒಂದ್ ವೇಳೆ ಅವರು ಸರ್ ಮತ್ತೆ ಬೇರೆ ಲಾಯರ್ ಇತ್ತು ಸರ್.
ಬರೀ ಒನ್ ವೇ ನಲ್ಲೇ ಹೋಗೋದು ನೀವು?
ಈಗ ಏನ್ ಮಾಡ್ಬೇಕು ಹೇಳಿ ಸರ್? ಆಸ್ ಪರ್ ಯುವರ್
ನಾವ್ ಹೇಳದ್ ಸ್ವಲ್ಪ ಕೇಳ್ಬೇಕಲ್ಲ. ಹೊರವಟ ಅಂತಿದ್ರ ಅವಾಗ. ಇನ್ನೊಂದು ಕೇಸ್ ಇದೆ ಅಂತ 4.5 ಲಕ್ಷದ ಅದೇನ ಸೆಟ್ಲ್ ಆಗುತ್ತಾ ಅಂತ ಕೇಳ್ತಿದ್ದಾರೆ.
ಅದು ಯಾವ್ದು ಯಾರು ಕುತ್ಕೊಂಡ್ರೆ ಸೆಟ್ಲ್ ಆಗುತ್ತೆ ಸರ್. ಯಾರು ಬರ್ಲಿಕ್ಕೆ ಲಾಯರ್ಸ್ ಆರ್ ನಾಟ್ ಅಲೋಯಿಂಗ್ ಟು ಹ್ಯಾವ್ ಎ ಕಾಂಪ್ರಮೈಸ್. The ladies are ready to have compromise.
Please will refer it before the mediation center. Sorry, Lokadal. The parties are directed to appear before the Lokadal on 11th. Next. No, it's now settlement. Komcham. Even there is nothing to be done.
It is also has presented the complaint of his father. He has executed GPA in favor of his father. For the complaint, there is no mentioning that the complainant and his father have transacted with the.
Sir, the executor an agreement of sale. Wait, I am arguing for execution agreement is admitted. There is a prior transaction that is also admitted. You say that you knew about the prior transaction. He has taken the risk of purchasing this property. So how can you sell what you did not have?
But subsequent to executing this agreement, Manoj, the person in whose favor he accused as executed the agreement, Manoj, he has purchased the. Manoj, and also Manoj, find fix the check amount, Manoj.
If you do not want the trial court to use its discretion, you should pay this money. If you invite the risk, then you are bound to face. I mean, get it. You should have offered this money. Correct, Mr. The moment he files a case, you must have offered this 32 lakhs to him. So you invited, you thought that, okay, let me drag on the case for another 10 years. You dragged it on for 10 years. Court is bound to pass an order. Twice to check them. In any NSC, in any bond, you are bound to get back double.
Is also filed with the.
You pay this money, they will withdraw the suit.
Also sought for interest.
Yes, Mr. You have that suit. What will be the amount payable with interest? 2014 till now, 6%, it can't exceed 6%.
The way the conduct of the
No, you work out for interest before the civil court. You direct him to pay the check amount. You give an undertaking. 6% on it. What is the principal amount? 30?
principal amount is 22 lakhs.
22 lakhs. Huh?
22.
You give another 5 lakhs. There's interest.
What is First year executed.
Sir, I've already dictated the judgment. I've already dictated, I know the facts.
Also, when we got an APP order. Then next year the APP order for some other property, even if that property also. But the accused do not become independent of the merchant or dishonour court.
Please come up with some settlement. Come up with some figure.
No, he will not come with the figure, he is doing it from.
You know it.
Yes, you are not because I participated in the mediation, you are not even ready to come to the mediation level. No, this is the fourth time I not get from the under the record of Karnataka.
44 lakhs is excessive. 44 lakhs is excessive.
And Russell from the records you will not get the.
We'll scale it down to 30 lakhs. 30 lakhs.
Here, you know, here they are checking that there is what we are the conduct of the
These suggestions demonstrate the transaction. Full stop. The trial court and the appellate court was justified in drawing a presumption under section 139 of the Negotiable Instruments Act. Since the complainant had established all the requirements for prosecuting the accused, and the accused did not come up with a plausible defense to rebut such presumption. In that way of the matter, the conviction of the accused for the offence punishable in section 138 of the Negotiable Instruments Act is unexceptionable, and the same is upheld. However, insofar as the sentence imposed by the trial court, the trial court has directed the accused to pay a fine of rupees 44 lakhs, being twice the check amount. Stop. The criminal case was lodged. The criminal case was filed in the year 2015. And it has reached finality before this court within less than 3 years. Within less than 7 years. The trial court therefore could not have awarded double the check amount as fine, as that would as fine. Having regard to the fine, to stop. Having regard to the fact that there was no agreement between the complainant and the accused regarding payment of interest, it is appropriate that the fine, that the sentence of fine imposed by the trial court is modified and scaled down to a sum of rupees 30 lakhs. You can go, Mr. The 9% tax is now. 9% tax. Please calculate 9%. Sir, 9% tax.
Already 10 lakh have already been issued by the complainant. 15 lakhs.
Yes. 10 lakhs is already deposited.
It was deposited and the complainant has withdrawn.
When was it deposited?
He was filing notes on 29/3/2021 notes of sending the for back to the
Okay.
Having regard to the fact that it was
The payment of interest, and in view of the fact that the complaint has already initiated the civil suit for recovery, this court considers it appropriate to scale down the sentence, scale down the fine imposed by the trial court from a sum of rupees 44 lakhs to a sum of rupees. ಆಯ್ತು 9% ಯಾಕಪ್ಪ ಇಷ್ಟ ಆಗುತ್ತೆ you undertake that you will withdraw the suit.
This order of 44 lakhs is confirmed.
9% ಹಂಗೆ ಕೊಡ್ತೀನಿ ನೀವು withdraw ಮಾಡ್ತೀರಾ?
Till the date of payment. Till the date of payment, because he will not pay the payment just yet.
9% I can't stipulate in the order, mister. It's not a recovery suit. You can't stipulate that in the judgment. Huh? To sum of rupees 32 lakhs. Which shall be paid by the accused within a period of 4 weeks from today. Failing which, the accused shall be liable to undergo simple imprisonment for a period of 6 months. There is no representation for the petitioner in the What is the transaction? What is the transaction? Transaction.
This other can learn from component for machinery and we take the interest that he has issued on
Chittu Vyavahara.
We are admitting the check and signature.
There is no representation for the petitioner the last time this time date.
Let's 43, 47 millet, sorry, 47 millet.
Yes, you missed the bus. Yes, 48. Who is R1, madam? You are for the petitioner. Who are the response to 1-3? Wife? Who are they? What is the allegation? What is the allegation? What is it she wants, madam? Where is Mr. Dilraj? There is no representation for the petitioner. The hardship for him. Yes. ಇದು R1 ಎಲ್ಲರೂ ಸೇಮ್ ಬೇಕಾಗಿಲ್ವಲ್ಲ. R1 is the husband. Next.
Mission mile 40.
Leader. ಬಂದಿಲ್ವಾ ಇವರು? ಬಂದಿಲ್ವಲ್ಲ, ಏನ್ ಮಾಡೋದು? ನೋ ರೆಪ್ರೆಸೆಂಟೇಷನ್ ಫಾರ್ ದಿ ಇದೆಯಲ್ಲ, ಬಂದಿದೆ. ನೋ ರೆಪ್ರೆಸೆಂಟೇಷನ್. ನೋ ರೆಪ್ರೆಸೆಂಟೇಷನ್ ಫಾರ್ ದಿ petitioner. As a last chance discount. The register is directed to secure the records of the trial court. Yes. So Srinivas. Even Radhakrishna. There is no representation for the petitioner and the respondent.
Mission mile 40. Serial number 47.
You missed it. Please wait. Yeah. Huh?
Yeah, I'm going to do this, it's going to be more quiet. Other parties. Who will say the serious dispute going on, compared to was quiet. Last week also quiet. The police. We are quite a person to judge it. The criminal appeal was quiet. The appeal was.
What is the case, sir? First you tell me what the case is all about. Yes.
138 proceedings. Plus the trial court convicts the accused on the basis of a joint memo filed between the parties. The matter had reached till the stage of final argument, at which stage a joint memo is filed indicating a judgment may be passed. However, the sentence to be limited to the amount in the cheque. Now, total transaction, there are two cases, my lord. Total transaction was 76 lakhs. That's the cheque amount. In one case, it is 40 lakhs. Other case, it is 36 lakhs. So, this joint memo which was filed, my lord, which my lord should kindly get, along with our memo dated 22/2/2022, the joint memo may be noticed, my lord. A memo dated 22/2/2022. Today we have another copy of that memo. The online order sheet is produced there, my lords, between page 2 and 3, my lords, to show that the matter was in the stage of final arguments. And the joint memo, my lord, to get at page 8, my lords. The joint memo reads, my lords, a short joint memo. Complainant has filed a complaint against the above accused reference and response. And the above case is posted for judgment. Now the accused have entered into a compromise the matter at the intervention of elders and family members. The accused agrees to repay the amount of rupees 40 lakhs within 4 months from the date of joint memo, that is 25 June 2019. Considering the above said fact, it is prayed to pass a judgment in the interest of justice. But this is not an.
No, what is this? Who is the complaint here? Kumar Babu.
Please, my lord, he is the petitioner, the division petitioner before my lords. He is the complaint. It's a complainant's division petition, my lord, because in appeal, this.
No. Complaint is some Muhammad Mansoor Pasha.
There are two matters, my lord. The first matter, in the division petition 1375, my lords, of 2019, Kumar Babu, my lords. So, my lords, this joint memo virtually was requesting the court to pass a judgment, but limit the sentence to the check amount of 40 lakhs.
Can the court pass a judgment of conviction based on a joint?
My lord, in so far as the sentence is concerned, I will show my lord the precedent, there are two precedents of this nature, my lord, one of our court, one of
Right.
Supreme Court.
Can you pass a judgment of conviction is what I'm asking. So 147 provides for compounding.
It's not the 147, 99 as a
It is not 147, right? It's not under.
It's more in the nature of pleading guilty.
Can this be treated as, at this stage, can it be said that, the accused is pleaded guilty?
It could be like that, my lord. And in fact, my lords, there are two occasions which I will point out, my lords. That is how even Supreme Court has considered. In fact, my lords, in one of the cases in the revision, my lords, a memo was filed. Conviction and appeal confirmation, revision, memo was filed. The court would convict and modify the sentence, my lords, and became subject matter of challenge in the Supreme Court. To confirm what the High Court did. Because case I will point out, my lords. So, my lords, in my respectful submission, this joint memo, my lords, in the nature of restricting the sentence, because otherwise it can go up to 2 years or double the check amount. Now, my lords, after all these proceedings, accused is willing to pay the check amount. That was brought to the notice of the court. Now, the court considers this, and in the order which is being passed, my lords, by the trial court, it was an order of conviction, but limiting the sentence to the amount agreed upon. This order of conviction before judgment was in Kannada, my lords, so it is translated.
But then what would happen is, the court should support its judgment based on the available material.
Yes, sir.
If it comes to the conclusion that there is a possibility of a conviction, then sentence.
So, my lords, I will point out both the orders of conviction in the two cases because it was in different courts. Court was quite convinced on the material, and then, my lords, places reliance on the joint memo, and then says, I'm convicting, sentence limited to the amount agreed upon between the parties. So, the first order is seen, my lord. This is the translated one itself, my lord, which we have given on 21 to 2022. Please notice, my lords, the discussion that is had, the presumptions that are there under the Act.
What happens before the appellate court?
Now, my lords, after this order is passed, the accused would resile, my lords. What he would do is, he would wait, my lords, beyond the period of limitation, files an appeal with condonation of delay, and in the appellate court, merely makes the statement, no, this joint memo should not be acted upon. It is because of coercion that it has been done. Now, based on this statement, without any evidence, my lords, the appellate court goes on to allow the appeal, sends it back, my lords, and what is hurting us most is to say, don't take into consideration the joint memo. My lords, then in that case, my lords, whatever is placed before the court will lose its sacrosanct. Now, that is what is hurting us. When parties have agreed, we have submitted 40 lakhs is to be paid merely by making a statement, no, don't act upon it, pass an order. Split court, my lords, has passed an order. And then this is the background of it, my lords. In my respect submission, both the orders of conviction, my lords, in both the cases.
Let us see the judgment of conviction.
Please, my lords. I'll also get it along with the memo dated 21/2/2022. Kindly notice, my lords, the discussion in this. My lords, the judgment starts with the index and then the brief facts of the case. Then from paragraph 5 onwards, my lords, the evidence that has been adduced, 5 to 9, heard on both the sides arguments, then the point for consideration, my lords, to notice, my lords, point raised for consideration, then the consideration points has been taken into consideration where paragraph 15, my lords, goes into the aspect of presumptions, and then, my lords, paragraph 17 may be noticed, my lords. This is where the court would come into the issue of joint memo. My lords, gets it, I'm sorry, my lords.
Just a moment. We're reading 1375.
My lords, in 1375, along with the memo dated 21/2/2022. My lords, in that,
Page number?
my lords, got that memo, my lords?
Yes, I have
Yes,
it.
my lords. It starts at page 2, my lord, before judgment starts at page
Memo 22.
21-2, my lord. One more memo is there.
Second and Marindra.
That's very well. 21-2. In the cheque memo, my lord, it only contains the judgment. Like just 21-2.
I'm sorry, it's not here. 21-2 illa. You read from the judgment of the trial court, it is annexed to the criminal revision petition. You are referring to 16351.
Well, it's 1375 in the revision petition 1375. That my lord.
CC number 16351.
Yes, sir.
Please read.
16351. Page 32, my lords, you get that. Alternately, my lords, as I had pointed out, my lords, initial portion of it, the index and the facts of the case, my lords. Point for consideration, my lords, to get page 35, my lords.
Page para 17.
Then, my lords, para 17, the page 37, the point for consideration, discussion on that. And then, my lords, the presumptions under the act. My lord, to get the presumptions also which has been touched upon. And finally, my lords, after doing all this discussion in paragraph 17, is this joint memo, my lords. Where it clearly says, my
No,
lords,
please read from paragraph number 15. Please read from paragraph 15. Let us see. You don't have the judgment with
and
you.
the judgment is there, my lords. Reading of Kannada is very slow, my lords.
Then we'll take it up on some other day when you are equipped with.
And it was a translated copy, I didn't.
No, no excuse, at least not in my court. You're not an Englishman. Though you look like one. It's an absolute disgrace. A colleague from
Allah, my lords, is that
no, a colleague can manage to read. You can't read Kannada. Absolute disgrace.
Allah, my lords. Quite frankly, my lords, the fact that I've been Madras for a number of years, my lords, then when it came, reading is okay, my lords, but the loud.
No. Yes. But the next time when you come
I
before
can
me,
definitely handle
please
my.
make sure that you don't repeat this submission.
But that's what I just read the portion out.
So you can ask her to read. Maybe you can listen to what she says.
I will just point out its exact translation, my lords. I'll just point out. It's mentioned the presumption in favor of complainant under section 118, 139 of the Act. And it is also made clear as to the date of transfer of instrument and how the presumptions are drawn. Once the complainant.
I'm sorry, that does not represent the correct translation. Both.
15.
ವರ್ಗಾವಣೀಯ ಪತ್ರಗಳ ಪೃಷ್ಠಾಂಕದ ಕಾಲಾನುಕ್ರಮಧಾರಕ ಇಲ್ಲಿವರೆಗೆ ಏನಿಲ್ವಾ? The court has only said what is 118,
What is presumption?
what is presumption. ತಡೆಯುತ್ತದೆ.
ಪ್ರಸ್ತುತ ಪ್ರಕರಣದ ಕ್ರಿಯಾಧಾರವು ವಾಸದ ಒಂದು ಮತ್ತು ಸಾಕ್ಷರ
ನೀಡುವುದಲ್ಲದೆ ದಸ್ತಾವೇಜಿ
ಪೂರ್ವಭಾವನೆಯನ್ನು ಕರೆಯಬೇಕು. ಈ ಪೂರ್ವಭಾವನೆಯನ್ನು ಖಂಡಿಸುವ ವಿದ್ಯಾರ್ಥಿಯ ಪರವಾಗಿ ಕೂಡಲೇ ಅದನ್ನು ಖಂಡಿಸುವ ವಿದ್ಯಾರ್ಥಿಯ ಕಡೆಗೆ ವರ್ಗಾವಣೆಯಾಗುತ್ತದೆ. ನ್ಯಾಯಾಲಯವು ವಿದ್ಯಾರ್ಥಿಯನ್ನು ಆರೋಪಿಯನ್ನು ರಚಿಸಿ ರಕ್ಷಣಾ ಮಾರ್ಗದ ವಿದ್ಯಾರ್ಥಿಗಾಗಿ ಆರೋಪಿ ದಾಖಲಿಸುವ ಪ್ರಕರಣ ವರ್ತಮಾನ ಪಕ್ಷಕಾರ ಜಂಟಿ ಸಲ್ಲಿಸಿರುವ ಜಂಟಿ ಸಂಗತಿಗಳನ್ನು ಇವತ್ತು ಸಾವಿರಗಳನ್ನು 4 ತಿಂಗಳೊಳಗೆ ಅಂದರೆ
ಎಲ್ಲಿದೆ?
Paragraph 13, 14 deals with all the documents being produced before the court. 15 comes to presumption. Then, my lords, when you come to paragraph 17, at this stage of final argument, this joint memo which was filed has been taken into consideration for the purpose of sentence. Now, my lords, if a joint memo was for the purpose of only compounding the offence, my lords would have noticed, my lords, section 147 NIR or under 320. Then, my lords, it amounts to an order of acquittal. But here, my lords, the intention was not that of acquittal from the parties. They asked for a judgment, but requesting the court to limit this sentence to the amount of the cheque and not more. Acting on it, my lords, the court convicts, it keeps the sentence at 40 lakhs. This is what is happening.
But what is there? There is a finding to justify a judgment of conviction. There is a finding of the trial court.
In a respectful submission, my lords, this virtually amounts to a case of accepting guilt.
No.
Under 355 for a reason, my lords. But my lords, 355 also, my lords, where they plead guilty, but on sentence. Now, on similar circumstances, my lords, a case which had come up before this honorable
No,
court.
I would accept your argument. I would accept your argument. For sentence, you can limit. no dispute. But for a court to pass judgment of conviction, that should be independent. Only when there is a judgment of conviction, then taking into account the joint memo, the sentence will be restricted.
The final portion of the order is seen in this, my lord. That is what the court has done. The court, my lords, has convicted under 255, the conviction is done, but limits the sentence on the basis of the joint memo.
Please come to this paragraph number 15. 15 deals with presumption.
Yes, sir. 13 and 14 is what is produced before the court. 13 is the evidence
These are the documents, correct?
produced before the court.
In fourth paragraph number 15, court says, talks about presumption which is provided under law. And the last sentence says that a presumption has to be drawn in favor of the petitioner, correct? Paragraph number 16,
Yes,
it only talks about rebuttal of such a presumption. Then it says, ದೃಢೀಕೃತ ಪ್ರತಿಗಳನ್ನು ಹಾಜರುಪಡಿಸಿ ನೀಡಿ 1 ಮತ್ತು 2 ಎಂದು ಹಾಗೂ ತನ್ನ ಮುಂದುವರೆದ ಮುಖ್ಯ ವಿಚಾರಣೆಯಲ್ಲಿ ಸಿಸಿ ನಂಬರ್ ಸೋನ್ಸು ಸಂಬಂಧಿಸಿದ ಫಿರ್ಯಾದು ಮತ್ತು ಇತರೆ ದಾಖಲಾತಿಗಳ ದೃಢೀಕೃತ ನಕಲುಗಳನ್ನು ಹಾಜರುಪಡಿಸಿ ನೀಡಿ ಎಂದು ನಿಶಾನಿಸಿಕೊಂಡಿದ್ದಾರೆ. ಫುಲ್ ಸ್ಟಾಪ್. There is no discussion by the trial court about the guilt, whether the finding.
I understand. Others could also have the other order of condition as per the other coordinate bench. It's dated 12th March 2019.
Is it by the same court?
No, different court. My lord will get that. In page 14, my lord, in criminal revision petition 796. My lord, the judgment starts at page 15, my lords. Complainant's case at 2 and 3. Then, my lords, from 8 onwards, my lords, summoning. Then 10, my lords, as per the direction of the honorable effects of page 80, my lords. Then, my lord, PW1 has been cross-examined by the learned defense counsel on the next page, my lord. During the cross-examination of PW1, certified copy of Form C, being the acknowledgement of register of firms came to be marked as Exhibit 3-1. Certified copies and so and so. Then statement of accused under 313, accused has been examined on oath as DW1 under section 315. Then in support of this evidence, DW1 has produced and relied upon documentary evidence, certified copy of FIR in crime number 93, P4. It is seen, paragraph 16, madam. It is seen that the case was posted for cross-examination. Both the parties identified their respective counsels have filed a joint memo before this court and considered submission to review the records carefully. 138 has been enacted to lend credibility to financial transactions. The main ingredients of the offense, the discussion my lord will get it there, my lord. Then comes apart from this para 19, apart from this one
Presumption.
Then 20 is again on 180 years. Then my lord, 22 under the scheme of the act, the onus is on the accused to rebut the presumptions in favor of the complaint by raising a probable defense. Preponderance of probability. A well settled position in law, defense of the accused. Yes, my lord. My lord, 24 is also a well settled position of law that once the check is put relating to the account of the accused and he accepts and admits based on the check, then initial presumption has to be raised. The presumption referred to in section 139 is a mandatory presumption. Please, 26 and in the present case, there is no dispute with regard to the acquaintance between parties, as well as with regard to the fact that the checking position belongs to the accused with his signature in it, and that he has issued the same towards the discharge of his legally favored debt in favor of the complainant. Now, my lord, so that initial presumption is there, my lord, we could go on to the accused to rebut it. Now, no rebuttal in this case, my lord. It's pertinent to note that also no dispute with regard to the fact that the complainant has fulfilled the mandatory requirement. Then it comes to the joint memo. Now, kindly notice this, my lord. It is seen that as per the joint filed by the parties voluntarily, which is duly signed by the respective counsels as well, and by them, accused has admitted the case of the complainant as well as his guilt under the subject check. This joint memo, my lord, it is the additional document Paragraph 3, this joint memo, page 3, my lord. Accused undertakes to pay the entire settlement amount of 36 to the complainant within 8 months without fail, for which complainant has agreed to receive the amount in said case and judgment can be passed accordingly. That in the event of default of payment, then my lord stipulated period is at liberty to take legal action. Then my lord, therefore it is prayed that this honorable court will take this joint memo on record and pass a considerable judgment in terms of the memo accordingly. Now this is the order passed. Now in appeal, my lords, if the court felt there should have been better reasoning given, my lords, the remand should have been along with what is there in the joint memo. Instead of doing that, the court wipes out the joint memo, my lords. That, in my respectful submission, my lords, is totally impermissible, my lords. You can't wipe out what is said just because an amendment is made at this question.
Then we'll say that this memo will be restricted only at the time of considering the sentence. Let the trial court redo the whole thing.
My lords,
See, there's no finding. If you read the entire judgment, there's no finding by the trial court whether the presumption is rebutted or not. There's no finding. The court has said this is the presumption, this is what has to be done, this is how it has to be done. But is there a finding that the accused by entering the witness box has rebutted the presumption? There's no finding. If that is so, we'll say that the joint memo will be kept alive only for the limited purpose of sentence. Yes.
I did what my lords is indicating. Plus one judgment which I will rely on, my lords, on similar circumstances, how the court today. Probably my lords may just consider the judgment, my lords, what happened in that case and what happened here. That was the case, my lords, where we don't get a full-fledged consideration before an order of admission. One of Supreme Court, my lords, one of our High Court.
We'll continue tomorrow then.
Tomorrow.
Okay, there must be one judgment, I think, somewhere in 2020 or 21. The Supreme Court has said, I think it might favor you more too. Where it said there can't be a judgment of conviction based on a joint form. Yeah, no, I'm sorry, I mean, I remember it.
Quickly, what is this?
No.
This is saying
2020
you
or
can't have a
20.
conviction on the basis
Can't be a conviction on the basis of joint form.
of the recent judgment.
Somewhere in 2020 or 20.
I did not say. These two judgments can be passed.
Good. Just tomorrow. Just tomorrow. Yes. Next number 54. For the respondent, thank you, Mark. And for the respondent, my lord, 54. Yes. My lord, this is the IPC matrix case, my lord. They obtained this this is arising out of the private complaint of a counter complaint, my lord. Yeah, what is this case? Yes, Mr. Subramanian. Right. My lord, the case to the case number 12, my lord. Here the complaint is made that misuse of the ATM card. Misuse of the ATM card, my lord. Yes, the complainant, the petitioner herein has made the complaint saying that the ATM card has been misused. Credit card, the ATM card has been misused, and he has suppressed the matter that he obtained the loan of rupees 32 lakhs, and towards the discharge of the same, he has issued the credit card to make use of the same, and thereafter he made the complaint against me, and I have sent to the prison, my lord. I have made this counter complaint, and he appeared before the honorable court and obtained the. You are the respondent, right? Yes, my lord. Wait for your turn. That is the urgency. So wait for your turn then. Let him argue. Yes.
Page number 12, paragraph number 2. The allegation is peculiar allegation. It is submitted by the complainant, it is submitted by the complainant and the accused. There are financial transactions between them. Reaction in the complaint is that the accused are filed a complaint of this case before DPR police as per the claim number so and so. What the offenses. This will take probably C and D of the. He has been arrested by the police. Complaint submit that he has given the handover to invest in the real estate business. In the case of the complaint, and apart from 52 lakhs, it also transferred 1 lakh rupees on 20% on each. Complaint alleged that the accused gave his ATM card and requested the complainant to withdraw the amount of. The complaint further submitted that the accused requested the complainant to keep the card and give the PIN charge covered custody bank and requested the complainant to withdraw. Change the PIN. Not in the complaint tried to withdraw the amount from ATM, but due to wrong PIN withdraw it. The complaint further contended that the accused by the complaint before the police alleging that the complaint has misused the ATM card. The accused only avoid the repayment of 17 lakh payable to the complainant. Complaint submitted that the accused has made the pre-plan to fix the complaint and has also ATM. Therefore, complaint is contended that the accused has committed a offence. 417.20. The accused in the complaint was the friends of each other. He filed a complaint with the card was debit card was lost, and that is been the whole. I have filed a complaint for.
When did you file a complaint?
But that is in claim number 165. What is the exact date? It is claim number 201 of the. Because what has happened is not the complainant hearing was arrested by the police. And it was being found that he is the one who has stolen my credit card. But it is his allegation. I have given him the credit card and made him to withdraw the money and gave him a wrong number so that he could not able to withdraw the money. The entire process is only to cheat him some money which I owe to him to avoid it and taken together the entire allegation. It does not come to either level.
Is the revision maintainable against taking cognizance?
397. So there is an initial question that has been asked about at the time of admission. Revision is permissible.
Is this an interlocutory order?
Interlocutory order was this taking cognizance on a protest memo. The courts have taken revision is permissible. I can play that. Because it decides the very existence and continuance of the complaint, and the way it decides the resolution.
Is there any other case? Which is the claim number that you said?
Claim number which they have filed is.
No, claim number which you had filed.
Which I have filed is 201 of 2017.
What is the stage?
But then that stage, the thing is the police have filed the charge sheet again. Cognizance has been. That is on the file of.
If both the cases go on together.
There is no offense only against the allegation.
That is right, but this has to be tested. Your defense has to be tested somewhere.
Testing of my defense, maintainability of my complaint will be tested in that complaint. But there is an allegation of my lord, the cheating, the ingredients of 417 420 required to set. Then only I can be charged. What charge that they can be used? The charge should be that I made a representation and he acted on the representation, suffered something, for which the thing is, with a dishonest intention of making wrongful gain to myself.
He withdraws 50,000 rupees once. He has withdrawn 50,000 rupees once.
Yes.
The PIN number is given by you.
PIN number is given by me, is his complaint. But where's the cheating ingredient?
Yes. Cheating ingredient should be brought. There must be it is his cases that entire falsity of the FIR is lodged on account of that in order to avoid some money that required to be paid. You have handed over the ATM along with the PIN and represented to him that he can draw money based on the PIN that was furnished.
What is the wrongful gain to me?
Wrongful gain to you is that the loan that you have raised from the complainant will be.
No, that is an independent recovery. Notice my client is serious. My client is appreciate this particular fact note. That if there was any action that has been filed against me for recovery of the money, and in furtherance of which I have done this, if there's certain reasons of that was a different issue altogether. But we assuming for a while, but take the entire case, I have raised of 30 lakhs. Then how does I be absolved of my liability? If by doing this, I should be absolved of my liability. Where is the absolving of
Maybe this is
liability?
one ploy that you used to implicate him in the case. We do not know.
No, it's even then.
How did you enable him to withdraw 50,000 rupees from your account using
No,
your?
no, I filed a complaint only saying I did not make any allegation against him.
What about this 50,000 rupees?
50,000 he had withdrawn, 40,000 rupees he had withdrawn.
50,000 rupees.
So 40,000 he withdraws.
Yes.
The first is 50,000 rupees.
Yeah,
Whereas my credit card was lost.
What is the
I
date? What is the date?
But I gave you the dates.
What is the date when you lost the credit card? When was this 50,000
When I
rupees?
can give you, I can give you.
Everybody.
I can purchase those disturbance. The actually, my lords, the only submission that I am trying to make is, my lord, it does not exonerate me of my liability on you. There is no unjust enrichment in my
That is
favor.
right. You are trying to implicate him in a case is his case.
Then it's malicious prosecution.
You don't know
Then malicious prosecution is different act.
you don't know what is the offenses that will be attracted. That will be
I should be charged with the specific offense.
charged later. Your plea will be recorded later, not now.
There is
The
a,
process is just issued to you now.
no, that's correct, my lords, but the complaint should make out an offense. I can produce all these dates and events, my lord, that may not be an issue.
Please produce all the
I
documents.
can produce all the dates. And in fact, police have investigated and filed a B report.
It's the only document that needs to be looked into. How did you permit him to withdraw 50,000 rupees using your ATM account and
Prima facie, I did not file a case against him at all. I
how
can,
did you get that? How did he get your ATM card, number one? Number two.
that's the allegation.
Then how can you say that?
Police have investigated and found
How
out.
to say, police told.
No, I'm not saying, police have investigated and found out. It's not my allegation, it's complaint.
How did
Produce that
how
complaint.
did you withdraw this 50,000 rupees from your account using your ATM with the PIN? Unless you disclosed it.
Not that's specifically a contention of mine. The thing is, how did he got it? I don't know. That is one the police required to investigate and find out. That's a different record. But I have never said in fact that he has stolen my credit card.
Right.
And
You look at this past transaction between you and him. There's a transaction.
there are certain transactions.
There are transactions. It could be 10 lakhs, it could be 50 lakhs, it could be 100 lakhs. There's some transaction. And this card incidentally goes into his hands. And he draws 50,000 rupees from your account using that ATM card with the PIN. The probability is that you have given the handed over the.
Maybe not. In that complaint.
That is so. You changing the PIN and still allowing the card to be with him. He going to ATM to withdraw the money and he getting caught.
They're taking together all these things, how does it go to cheating?
Does not become cheating.
Both ways is the allegation.
But there's an attempt. There's an attempt to implicating him in a case.
Assuming right, things I'm not saying that things have falsely implicated. The allegation then charges a criminal law basis on charges on that.
He's not reached the stage.
Yeah.
His cognizance is taken, that's it.
No, sleeper. Police have filed B report and thereafter he has read this full statement on which cognizance has been taken. I can give the dates and
Give the dates, give the dates.
Okay.
The request of learned counsel for the petition on this point.
22nd is second notice now.
So date.
Interim order mechanic.
For the change in the state of.
And another case on also.
Yes. Dilemma. Event. Paragraph number 1, paragraph number 2.
ಹೀಗೆ ಸಾಯ್ತಾರೆ ಅಂದ್ರೆ
Book of 10 lakh.
Parties have filed a joint memo which is treated as an application of section 147 of the Negotiable Instruments Act. Parties have settled the dispute at a sum of 7.5 lakhs towards the full and final settlement payable under the check in question. Of 7.5 lakhs, 2.72 lakhs is paid by cash by the petitioner to the respondent, which is acknowledged. The sum of rupees 4.78 lakhs, which is deposited by the petitioner before the trial court, shall be released in favor of the respondent. View of the settlement, full stop. The joint memo is accepted. Consequently, the revision petition is allowed. The offence committed by the petitioner under section 132 of the Negotiable Instruments Act is compounded. Resultantly, the judgment of conviction debits onto each one. The amount in deposit is ordered to be released to the respondent. There is no representation for the, if you want of time, the petition could not be taken up. This term date. Hardship. I am willing to work, Mr. If you are willing to work. Ready? Not ready. Huh?
Settlement of.
Joint counsel for the petitioner submits that the parties have worked out a settlement and would report the settlement shortly. This turn. Yes. Mara. Desai Rajendra.
For the respect, my lord.
What is this case?
No, I'm ready to pay check amount.
Check amount, are you willing to accept, Mr.? When was the
11 lakhs is order. Honorable court was passed an amount of 11 lakhs, my lord.
1 lakhs.
What is the check amount?
7 lakhs.
7 lakhs. Are you willing to accept 7 lakhs today?
I'll discuss with my client. My inform date may be fixed, my lord.
Sir, 2017, 5 ವರ್ಷ ಆಗಿದೆ 7 lakhs, 7 lakhs ಕೊಡ್ತೀನಿ ಅಂದ್ರೆ justified argument. Come up with one more figure. 7 ಮತ್ತೆ 11 ಮಧ್ಯ 9 lakhs. 9 lakhs ಮಾಡ್ಕೊಂಡು ಕ್ಲೋಸ್ ಮಾಡಿ. Be reasonable.
Date may be.
Yes, look on date. Yes, Kumbidi. What is this?
Amount of 30 lakhs. It has to pay around 50 lakhs.
3 lakhs.
10 lakhs.
ಮತ್ತೆ ಎಷ್ಟು ಡೆಪಾಸಿಟ್ ಮಾಡ್ತೀರಾ?
Transaction.
Don't argue on merits. This is a revision petition. Issue notice regarding admission. Also suspended subject to the petitioner depositing. Check amount ಎಷ್ಟು?
Check amount is 30 lakhs. This is number 25.
20 lakhs, including the amount already deposited in a period of 4 weeks.
Huge amount. 30 lakhs is the.
ಆನೆ ಬರ ಇರುವೆ ಬರ ಏನ್ ಮಾಡಕ್ಕೆ? No, Mr. Not 8 weeks. First you deposit ಮಾಡಿ. When you seek for extension, there is a way of doing it. ಒಂದು 10 ಲಕ್ಷ ಕಟ್ಟಿ ಒಂದು ಅಯ್ಯ ಹಾಕಿ. List on date.
Petition. Compulsory order.
Right, 11th Lok Adalat is covered. We'll release the money then. The money deposited by you will be released to the respondent. ನೀವು ಡೆಪಾಸಿಟ್ ಮಾಡಿರುವಂತ ಹಣವನ್ನ ಪ್ರತಿವಾದಿಗಳಿಗೆ ಬಿಡುಗಡೆ ಮಾಡೋದಕ್ಕೆ ನಿಮ್ದೇನು ಅಭ್ಯಂತರ ಇದೆಯಾ? Grant counsel for the petition and the respondent subjects that the parties may be directed to refer to Lok Adalat. Refer to Lok Adalat for settlement. The parties are directed to appeal before the Lok Adalat on 11th. 11th. The amount in deposit is ordered to be released in favor of the respondent. The amount deposited by the petitioner before the trial court is ordered to be released in favor of the respondent. Which I said.
It's already granted in the model.
ये put up party वाला. Yeah. We one of 23 is filed for extension of time to comply the order dated 9/1 2023. The cost one for ಎಷ್ಟಾಗುತ್ತೆ?
15 lakh.
Cost one for seeking extension of time, is accepted. The time prescribed for depositing, the time provided under the order dated is extended to 2 more weeks. It is made clear that if the amount is not deposited within 2 weeks from now, the respondent is at liberty to execute the order of sentence in accordance.
This offense is 392. Court was pleased to convict the accused for 2 years.
If the court was pleased, why do you file a revision?
Out of 10 witnesses, 5 witnesses has been examined by court.
If the court was pleased, why did you file a revision then?
Yes, on marriage, my lord.
I heard the Artham. If the court was pleased, then why did you file a revision?
Aggrieved by the order of judgments.
Well, yeah, what is the recovery? What is recovered?
One gold chain. The accused was arrested in 399 402, and the court has examined the police witness, which they are not aware.
Any other cases are there in this?
No, my lord. Only for 392.
Are there any other cases? Find out if he is a habitual offender. They are going to see which is liable to accept notice for the state. Counsel for the petition. Copy there. Copy is furnished. List on ಯಾವಾಗ ಹೇಳ್ತೀರಾ? He is directed to ascertain whether there are any other cases registered against the petitioner. List on 9th. Yes. If I remember, you had relied upon some judgment of the court in terms of this court. Rendered by just.
Yes, anything regarding the something such as demand of the order. The lower court order, it has been clearly stated that not question the validity of the assessment order. I am not considering any validity assessment order before lower court. The only submission before lower court that demand of the assessment order legally served. That take consideration the officers to mother. For the mother, the demand is their officer is not accompanied by any local witness. That is very clear. And that continuation I have taken before the lower court. And lower court has not decided anything
When will you
regarding.
get a notice? You bring it, you come up with a notice, you please serve it in the court itself.
Earlier, the once Melody is in the presence of the application, the justification the amount. So the of the arbitration. Notice in the house of the petitioner in affection. Third office Melody is left out. He gives the announcement only one address to the state of
Local witness. It's a murder done by the commercial tax inspector. It is not that the daily records and for which.
Where is the objection? Where is the objection filed by you before the tribunal, before the sales tax court?
Page number 76, regarding the validity.
Yes, please read your objections, please read your objection. What?
There is no valid service.
Where's the act, where's the requirement of service? Which is the provision which requires what? KV Act. KVA Act. Both.
If it's a stealer or its manager or its agent, if the stealer or its manager or agent is not found by the beginning, not.
What is the mode of service now adopted in your case? Fourth one. Fourth. What is the requirement? None of the modes aforesaid is practicable by affixing it in some conspicuous place at his last known place of birth. So therefore, where is the requirement of getting a mazel drawn? Oh, where's the mazel? Are you still doing business in this address? Huh? Mister? Still there. What is the proof? What is the proof that you have produced? Yes, Mister. What is the proof that you are still there? Sundara Builders, not the Aadhaar card. I want the business proof to show that Vasundhara Builders is doing business in this address. Because now you say, please wait. Now you say, Vasundhara Builders 75/2 Ring Road, Vaskirel Tank. The address earlier was 286/8, new number 28, Sriram Mughali Road. Huh? Then what is, therefore, what is there to show that you are doing business in Vaskirel? Photographs idea? Kodu.
The receipt is updated, earlier is some amount is fixed. After that, the restitution, amount, that after is passed the order. After the restitution, the presence of appeal, received in notice. What I am there. The knowledge is very clear. The view is pending, not ensured.
So who are this? No, who are this? Who are these people? Who are this? Sir, who are these people, sir? Who are this? Photograph. One
of the officers.
See the notice sent to you by, please wait. The notice sent to you by RPAD, it is returned. Addressee left. If the addressee has left the premises, then how do you say that they are not visited? How do you say that they are not conducted a mazar? How do you say that they are not affixed?
How they have protected the public include the road code. And road code has not passed any order regarding this measure. And regarding demand for this also, they are not. Whether it is done or whether it is not been done, they will not be discussed with road.
What was it?
Whatever the architectures we have tried, whether it's stated in the order, but no orders are passed regarding
Page number 20. Respondent file of return application stating that application file will be reviewed for taken opposition. It has been stated in one of the seven.
Legal witnesses. What is the requirement of law? That it has to be affixed in the. So that is your word. It has not been stated. It has not been stated.
This is so valid. It is very clear that that is not.
So therefore, you say that two witnesses have to identify. Where is the law? Where is the law? Where is the law, sir? The two witnesses have to identify the affixture. If it is one, then it can be two also.
Whether the government tax inspector, because whether they fix the workings of product, Because they strictly, legal.
So they have produced, they placed on record certain photographs which shows that they have affixed the notice on that day.
Photograph data and seeing how.
There are copies of the photographs.
You get your photograph.
That is all. There is no requirement that there should be two witnesses. Oh. You please find it.
In other cases, they have made witnesses.
Sir, there should be a law which provides for who mode of service. If the law provides, then you are right.
Again, valid service is necessary.
Correct, sir. The law should provide for itself.
This is valid.
Good. Learn counsel for the petitioner each time. This time, when do you want it? Okay, out on photo. Yes, next. Mr. Prateek. ಯಾವತ್ತು ಬೇಕು ಅದು ಪ್ರದೀಪ್ ಕೇಸಿ learn HCGPS director accept notice ಆಗಿದೆಯಾ
Village and all, 5,000 rupees, 1,500 days. And for the record.
Call for records, call. List after service of the lower court records. Mr. Jairaj.
And challenge the order of charges. Meanwhile, I came to know my friend, one of the offenses are section 9 of the protection of depositors interest act. One provision. That provision, there is an appeal provided as section 16. Therefore, I am permitted this one as appeal as my memo. I don't have appeal.
Learn counsel for the petitioner has filed a memo to convert this revision petition to a criminal appeal. In view of the memo, the memo is accepted and the petitioner is permitted to convert this criminal petition to a criminal appeal. For statistical purposes, this revision petition is treated as closed. Counsel for the petitioner is directed to make appropriate corrections to bring it in line with the format prescribed for an appeal. Yes. Mr. Babu Rao. Due to want of time, the petition could not be taken. This time. Issue notice regarding admission, 50%.
Serial number 69, and for the
same one.
Petitioners in this matter.
50% you deposit.
My lordship, the check amount is 10 lakh rupees. My lordship, the fine amount is at 15 lakh rupees. So kindly.
What is the fine amount? 50% of the fine amount, including the amount already deposited.
Grateful.
4 weeks.
47 B. Submission, my lord. Serial number 47, my lord. Taken at least on Monday, my lord.
Yes, date put to the note.
47.
We are giving short dates only. Please wait. Dispose as dealing settlement. Settlement. Your date put to the notice. Number 40. I think the short date is given.
Hello.
Wildlife ಬೇಡ. ಸರ್, ನೆಗೆಷಬಲ್ ಇನ್ಸ್ಟ್ರೂಮೆಂಟ್ ಆಕ್ಟ್ ಇಲ್ಲ. ಎಲ್ಲಿದೆ? ಇಲ್ಲಿಲ್ಲ.